Okay, Catch of the Day Video News. It's now 5 of 1, and this is going to play. Just going to record random until it starts.
Yeah.
And I'm sure you could. I'm sure you could have LIS on that.
I would even if you just said the clock, I'd be fine for going in. I'm sure they could bring in a second one if you wanted. But I don't think we probably don't even need it. I don't feel like
I'm sure they could hook it up.
yeah, but I think the timing would work. Because the last couple of years we never
signs up? If what? Yes. Or at least to say everybody's name very clearly.
How are you, sir? basically it's committed staff. I talked to the chairman. Sends out the numbers. Is there any way you can get a shot of this?
I'm Will Brownster. I'm the Senate co-chair of the Joint Judiciary Committee on the Judiciary. To my immediate left is Representative Claire Crone, who is let's work on this here. Is this getting better? How about that? Is that, can you hear me? Back up there? No. Not very good. Where is... So we're gonna get started with, I'm gonna do my best to speak loudly, but reciprocally, you know, everybody else will be able to hear best if nobody else is talking. So if we can observe unusual silence in this room, we will be able to get through this with perhaps inadequate sound systems. So to start over again, I am Will Brownster. I am the Senate co-chair of the Joint Committee on the Judiciary. To my immediate left is my House co-chair, Representative Claire Crone. I'm going to ask Representative Chair Crone to introduce the members of the House who are present with us this morning.
Thank you. On the far left is Paul Donato of the staff of the Judiciary Committee. To his right is Representative Jim Lyons. To Jim Lyons' right, Representative Mike Day. And then we have Representative Sheila Harrington, who is the ranking minority leader. Gretchen Beck is to my left, Chief Legal Counsel of the Judiciary Committee. To the right of Senator Brownsberger is Representative Jim Campbell, Vice Chair of the House Judiciary Committee. To his right, Representative Paul Tucker from the city or town of Salem?
All right, thank you very much. And I've got a couple of staff members with me who will be coming in and out. Thank you all for coming out. Obviously, there's a lot of bills, some major issues, a few major issues, and then some other issues that also have a lot of people concerned. So everybody who's here today will be heard if you wish to be heard. But I want to talk about how we're going to go forward with that process and give people a few different ways to express themselves. Different things are happening in this process. One is we, the Judiciary Committee, are listening and trying to actually learn about the substance of these bills and understand some of the technicalities. So that's one of the things that's going on. Two, you, by testifying, are informing the public at large. So we have lots of press in the room, they're paying attention. People are watching this, some of this on television at home. Everything here is on the record. Everything you say here is on the record. We'll actually be tweeting some of it out as it goes. We just try to sort of keep a little bit of a running record going if we can on Twitter. So that's one of the other things that's happening, is we're informing the public. This is also an opportunity for people, and I see it in the room, people are just trying to show the level of support for different ideas. We've got people wearing t-shirts. Just by walking in here with a t-shirt, you've expressed yourself already, showing what your concern is, and so we appreciate that. And we're going to try to give people the opportunity to do some shows of hands and that kind of thing, so that people who may get tired and have to go, we'll be on the record on some of the issues they want to get on the record on. And of course, this is also an opportunity for legislators to communicate their views to the committee and also to let you know what their views are. It's important for legislators to take their stands, and so that's some of what is going on in this room today. We're going to ask everybody to observe a 3-minute time limit. You can that's 3 minutes per person, not 3 minutes per issue. If you do want to testify on a second issue or a second block of time, we will allow that, but that will happen at the end of everybody else having testified once. So everybody gets one 3-minute shot, and then we go on around. We've been joined by Representative Carol Viola. Thank you, Carol, on the far right. And members who are sitting up here for the first time with these new microphones should know that when you press them and the red light is on, you are on. And when the light is not on, you are not on. So when you want to talk, make sure you press the red light. The way we're going to try to approach this hearing is by topic. So we're going to take people in the order that they signed up by topic. And as you came in and signed up, you were asked to identify what category of topics you were in. And our intention is actually to take the most numerous topics first and sort of work through the things that are going to get the most people the chance to express themselves earliest. The topic which has drawn the most, which people have most assigned themselves to, is the topic of collateral consequences. So that is what we are going to start off with. In that category, we have Secretary Bennett, I believe, indicated that he was here. The Governor's Secretary of Public Safety is here and wishes to testify. And we will, I know there are some legislators that have particular schedules, and we're going to work with legislators who are in the room so that they have the opportunity to speak to the public on these issues as well as their opportunity to do this. Secretary Bennett, thank you for being with us today. We hope that microphone is on, and we'll all try to do our best to talk right into the microphone, so just about kissing that thing.
Thank you. Good afternoon, Chairman Drosberg and Chairwoman Cronin. I'm here testifying on Senate Bill 2050. In the past, I've been first assistant to Joe Early out in Worcester, and I've been a defense attorney for 8 years. And I did a lot of my work in criminal law, both in the Superior and District Court. And what I noticed when I was out there was that a lot of the defendants who had pled to both serious and not as serious criminal offenses had a lot of difficulty paying their fines. And as we see in a lot of situations, the individuals, because of their criminal offenses or for other reasons, were unable to gain employment. So the judges were doing what I consider the right thing and giving them an opportunity to community service. What was the biggest difficulty I saw with that was $30 a day was a woefully small amount to be acquired for that. And they weren't able to pay off their fines. Well, what this bill does is have them get $90 a day for community service. To put that in perspective, when $30 was the amount that every individual got, that was back in enacted back in 1987 when minimum wage was $3.65. Now in the Commonwealth it's $11 a day. I think out of fairness and out of an opportunity for individuals to be able to work off and actually contribute to society if they can't pay those fines, I think that's a reasonable amount to go up to $90 a day. If they can't pay the fines, there is a provision within this bill that before there would be any consequence of them being incarcerated, they're appointed an attorney, and they have an opportunity for a judge to waive those fines entirely if because of some issue at home or some issue with transportation or some other issue that they can't pay the fines. So I think it's a fair bill, it's the right thing to do, and it gives an opportunity so that someone is able to meet their obligations to the court and to society without, if they can't financially do that. If there's any questions, be happy to answer them.
Thank you for your testimony. Thank you for your leadership on the issue. Thank you for your testimony and thank you for your leadership on the issue. Are there any questions from members of the panel? Thank you so much for coming and putting yourself on the record. I really appreciate it.
Thank you very much.
I know that Senator Spilka is here. It's a combination of juvenile and collateral justice issues, juvenile justice and collateral consequences issues throughout the panel. We'll take the Senator Spilka. And I apologize for the fact that there are really only two places at this table. So as panels come up, somebody's going to stand, but you should feel very comfortable to testify on your feet if you are testifying.
We've discussed
sitting
that.
or standing is fine.
Yes, we'll rotate out, so we'll work with everybody.
You do not have to be seated to testify.
Okay. Thank you, Chair Brownsberger and Chair Cronin, and members of the committee for the opportunity to testify. I'm here with 3 young adults from Teens Leading the Way, Idris, Sharice, and Jefferson, who will be brief as well, but very important to testify. And I want to thank Representative Khan and Representative Peake, who are the House counterparts for the bills that I'm about to speak to. I'm here in support of 3 bills: Senate 947, an act promoting transparency, best practices, and better outcomes for children and communities; Senate 944, relative to expungement; and Senate 943, an act to protect electronic privacy. First, I'll address Senate 947, and I will try to go through it somewhat quickly, but it's a juvenile justice omnibus bill. We worked with the Citizens for Juvenile Justice, and we put together a bill that addresses some of the key issues that need reform in our juvenile justice system. It reflects the best practices to reduce crime, save money, and help young people learn from their mistakes. To that end, it would gradually raise the age of juvenile jurisdiction to under 21. It would raise the lower end of juvenile jurisdiction from 7 to 12, and decriminalize certain nonviolent offenses and divert low-level children from the formal judicial system. Gradually raising the age to under 21 is the center of the bill. Many of us are aware of the statistics. In Massachusetts, we spend the most on this category of emerging adults, yet this group has had some of the worst outcomes. They are the most likely to reoffend. 76, and I say 76%, of emerging adults released from the House of Correction in 2011 reoffended within 3 years. But research shows most of these young adults do mature out of crime by their mid-20s, particularly when they have the appropriate interventions. So we took an important first step to address this problem when we raised the age from 17 to 18. And since then, it's important to note juvenile crime has actually declined by 34%. And the number of youth in state juvenile facilities continues to decline. This omnibus bill would take the next step by gradually raising the age to 21. And the bill also codifies the juvenile court standing order, which prevents youth from being held automatically into shackles during court proceedings. It is an embarrassment that we in Massachusetts still do this to our young adults. It codifies the youth services prohibiting the use of solitary confinement. And it creates a juvenile justice task force. Finally, there's the next piece, and you will hear the young adults, and I'll let them speak because I think they will be even more, have a stronger impact than I would on filing a bill to expunge records, criminal records in Massachusetts. I think that, again, I will let them, but it would expunge misdemeanors if there's been no action and allow a felony, the person to petition the court to expunge a felony, but not for a violent crime or for murder. Research backs up expungement. In fact, a recent MIT study recommended very strongly that Massachusetts should follow the few other states that have expungement. Again, I will let the young adults here. I do want to very briefly mention the Electronic Privacy Senate 943. In this day and age, this is an incredibly important bill. These records on our laptops, our cell phones, if they were in a regular folder, a file that's somewhere in somebody's office, they would not be accessible without probable cause and a warrant. That is not the case right now, so I urge you to please report out all three bills favorably so that the legislature has an opportunity to pass them this session. I will now turn it over to the young adults because they are the most important of this panel. Thank you.
Thank you very much.
Can everyone hear me? Properly or?
You'd have to speak up or just try speaking real loud, see if that works.
All right, is this better? Yeah. All right. So, hello everybody. My name is Idris Abdullah. I'm a member of Teens Leading the Way. I go to UMass Boston, going to my junior year.
Keep it up.
Sorry.
Yeah, maybe use the microphone. I hate to say it. I know.
All right.
You can hold it. You can hold it if you want to stand.
All right. So, can everyone hear me now? Yeah. All right. Sorry. As I was saying, my name is Idris Abdullah. I'm a member of Teens Leading the Way, and Teens Leading the Way is a statewide youth-led policymaking coalition in which we kind of, as we're here now, we push for bills to be made that hopefully will affect our youth and make our lives a little bit better, considering the situation that we find ourselves in sometimes. We are a member of, I'm sorry, it's nervous.
It's okay, you're doing great.
Take your time, you got the pressure on you, just take your time.
All right, we are made up of the Hope Coalition, Teens and Ever Against Substance Abuse, I Have a Future Group, Straight Ahead Ministries, College Bound in Dorchester, and also more groups. We are here right now in support of bills H2309 and S944. Teens Leading the Way was founded 12 years ago and has worked on a few bills, including supporting people with mental impairments, adding civics to our classrooms, and now we are pushing for expungement of juvenile records. One reason for deciding to promote expungement is simple. Young people need to understand that although they are going to make mistakes and they are going to be punished for it, they can be forgiven for the things that they've done. It's not fair to youth for them to have permanent stigmas for mistakes that they made at an age in which trial and error is expected, in an age in which we are trying to find our way within the world and find out where we're supposed to be. Of course, these bills need to be filed in order for us to be here in front of you all today. So I'd like to take the time to formally thank Senator Spoka as well as Representative Conan Dykma for helping us get to this point, and also my own representative, Evangelo Carvalho, for his support. Well, I would hope that you all would pass the bill favorably and make a better future tomorrow for the youth that we have today. Thank you.
Thank you. Great job.
Now listen, one thing we didn't talk about when you started is, I'm going to give you the opportunity to say I support this thing, but let's not get into clapping and booing because that can go in a bad direction eventually. It can get intimidating for people. So let's let the people speak and let the next person speak like that. So yes, ma'am.
Hello, my name is Sharice McMillan. I'm a student at Lesley University. I'm 19, I live in Boston. So I'm here to talk about a little bit more of the details of the campaign and about Teens Leading the Way, how we came up with this idea. So Teens Leading the Way brainstormed for about 2 years before we decided to work on expungement. The members at the time found this topic really relatable, and a lot of their friends and the organizations we're partnered with are affected by the criminal justice system. So after 4 years of working on expungement, our current members feel the same way. Youth are usually left out of the conversation when criminal justice reform is discussed, even though they are heavily affected. Not only are their peers involved, but their parents, valued family members, and even themselves are greatly impacted by the faults in our system. There are a few main reasons we would like to stress to make expungement super important. The first is that having a record is a huge obstacle when it comes to housing, education, and employment. Without a home, an education, or a job, how can we expect someone to successfully rejoin our community? The next reason is, like most people, we believe that everyone deserves a second chance. A person should not have to suffer for the rest of their life because of something they did when they were 17. A sentence should be their full punishment, and their punishment shouldn't have to continue on for the rest of their lives, even after their time is served. The last main reason is if we could reduce recidivism by just 15%, our state would save $150 million. And with the opportunity to move forward in life, get an education, a home, and a job, there shouldn't be a reason to go back to jail. And also just a little bit about the MIT study. In July of 2016, they released their health impact assessment. The study found that youth with criminal records have a higher rate of mental illness than the general youth population. And just to go on to explain, the actual bill. Currently, youth must wait 3 years to get their records sealed, even if the case has been dismissed. And we would like to make it so that if the case is dismissed, your record can be expunged immediately. Also, after 1 year, you can petition to get your record sealed, and after 3 years of good behavior, your record could be expunged automatically. If a felony was committed, the person must petition to have their record expunged. For extreme cases where your sentence technically would not end, like if you were on parole, you would be on parole, or if you're registered as a sex offender, you can't get your record expunged because your sentence doesn't end. So yeah, that would conclude what I have to talk about today, and thank you for listening.
Thank you so much.
Good job.
How you doing, Senator and Representatives? Good afternoon. My name is Jefferson Alvarez, and I'm 21 years old. I live in Lawrence. I'm from an organization named UTEC, and I'm here on behalf of Team Leading the Way. I'm here to tell my story, so thank you all for listening to me. Before I begin, I want you all to know that there are many peers behind me that I work with from all around Massachusetts who have similar stories just like mine, and it's an honor to speak on behalf as well. 7 years ago, freshman year of high school, I got into a fight. It was the middle of winter, cold out, and I saw another student looking at me funny. I approached the student, and we exchanged words. Something in my head clicked, and we ended up trying to fight. Before a punch was thrown, school security guards pulled us apart and called the police. The police arrived, handcuffed me, and brought me outside to the police car. I felt like a criminal, like I had done something beyond that, terrible. Sorry. The police ended up bringing me home, and I was summoned to court. At court, the judge told me to stay away from the victim, and I was removed from the high school and put into alternative school. At my new school, I kept getting into fights, and I kept getting arrested. One led to me getting charged with an assault and battery with a dangerous weapon because I kicked another student with my shoe. Eventually, I was expelled from school and committed to the Department of Youth Services, where I started meeting young people just like me and hearing their stories. I realized I hadn't done anything nearly as wrong as some others, and it made me think about life. My experiences in DYS, how to respect others, I hadn't learned yet. After DYS, I started realizing that there were better ways to approach people and that fighting people was not the appropriate way to get respect. Now, I feel like I get more respect for talking it out than fighting. This led me to UTEC, where I now work for a cafe crew. We make some awesome pork panini, guys. And my goal is to get my GED and begin paramedic training, since I worked the last few years as a lifeguard in Lawrence through the DCR. This expungement bill will help me directly because I have many juvenile records that even ICEL couldn't hold me back from my life goals. See, I really want to work with kids, but what if I wanted to be a foster parent, or what if I wanted to run a daycare? Sealing a record ain't helpful, but it's not enough. Because of one mistake in my life, I began a long path that pulled me from school and got me deeper into the streets. I'm 21 now, and I'm still fighting for my GED. I'm 21 now, but I'm not who I was when I was 16. I'm full of mad love. I will soon be able to seal my records, which means if this bill passes, I could expunge my records my juvenile records by the time I'm 24. I'm here to ask you to help me get back to my future that I left off chasing 7 years ago. Please pass Bill S944 and H2309 favorably. It won't only help me, it will help thousands of young people who are stuck in the same situation as me. Thank you.
Thank you very much. Thank you. I'd like to thank you very much for your testimony. Any questions from members of the panel? All right. Everybody who is in support of this testimony, please rise and raise your hands. Stand up, raise your hands. You made it.
Good job.
There's a clear message from the room on that.
Right.
Thank you very much.
Thank you. Could I just add that it's clear by the testimony of these young adults that our future is in very good hands. Thank you.
Thank you.
Thank
Stay
you.
up here because I guess we got a question. Representative Lyons.
Thank you. First of all, thank you very much for your testimony. My question, though, is not regarding that specific legislation. Senator, it's regarding the transition to the 18, 19, and 20-year-olds and how that will impact DYS, and is there a process in place? Because it seems to me when we begin putting young adults, 18, 19, and 20-year-olds, with young teenagers, 14, 15, 16, and 17, there could be some kind of major issues there. Is there a thought process in place, and how are we going to establish that, and what is the plan to do that going forward, if there is one?
I just want to say initial discussions have started with DYS, but their population has dramatically declined. So there is room to put, especially if we phase in the 18, 19, 20-year-olds, there is room to do it and keep them somewhat separate. The whole idea would be possibly to separate. But you have to realize now that we have 18-year-olds with 30-year-olds possibly, or with other adults that are being influenced by the adult population that are still young minds. So, you know, you have it on the other end, and that is part of the reason for this bill. But then to better plan the space, the phasing in, to make sure that it works for all age groups.
Because isn't it true that the training for the folks who take care of 14 and 17-year-olds would be dramatically different than the training necessary for people to take care of 18 to 21-year-olds? And that's my concern, is that by doing this, we've got a program, as you just indicated, that seems to be working at the juvenile level. And once we begin to put in older 18, 19, 20, 21-year-olds, because the young man he's totally different today than he was, in a better way than he was then, but that can also work in reverse. And my concern would be by putting them all together, lumping them all into the same organization could be a potential problem. I support the idea of definitely giving help to these young adults. However, to put them into the same program of a younger program, I think is something we really have to consider.
Well, that's what I'm...
Senator, should these be making a statement? The statement's made.
Okay.
Thank you. Let's keep moving.
Thank you.
Thank you very much. All right. So now, next on the list, I've got, or actually really first on the true list here, I've got Representative Keith and Senator Chang Diaz. What I'm going to start doing, by the way, is telling people who's up next so that they know. While Senator Chang Diaz and Representative Keith come forward with their panel, I guess they have Mr. Foreman involved as well. I want to tell you, are there a group of DAs here? Where are they? Over there, okay. We're going to get you up next.
Good afternoon, Mr. Chairman. In the interest of time, I'm going to start while setup is happening.
You can start going, please.
So, good afternoon, not just to the chairs, but also to the rest of the committee. Representative Keith and I, joined by our colleagues from across the state who are sorted throughout the room here.
Wait, hold on a second. Do you want to bring people to be forward and stand behind you in support of this?
I think the committee is going to receive a letter of signers, so again, just keep it simple logistically.
Okay.
I'll direct your attention to that. But we're here to offer testimony on the Justice Reinvestment Act, House 2308, Senate 791, and to urge the committee to take comprehensive reform and to make it the priority for this session. Our omnibus bill includes provisions to eliminate mandatory minimum drug sentences, to raise the felony threshold in larceny cases, to update and improve, thank you for the note.
By the way, the witnesses, you'll notice there's a plus and minus button on the microphone now there.
Yeah.
Just make sure the pluses, bang that plus again a few times, that may help a little bit.
Does that help?
Try it. Just keep talking.
Keep talking, all right. Provisions to update and improve our quarry laws, to create medical parole mechanisms in the Commonwealth, and to reinvest savings from these reforms, which would be realized both from a reduction of the number of people that we're incarcerating and also the terms of their incarceration, reinvesting those savings into community education and workforce development programs. Today I'm going to focus my remarks on the first three of those items, and Representative Keefe is going to cover the latter two. As has been well reported on of late, criminal justice reform is on the minds of our colleagues here in the legislature and the constituents who sent us here. We know that the criminal justice system is racially biased, that it's ill-equipped to provide correctional or rehabilitative services currently, and it is hugely expensive for taxpayers. We also know that there is no silver bullet at our disposal, no one policy change alone that will right the wrongs that have been done to our residents, to our high-crime neighborhoods, and to taxpayers by a failing system. But we can't let the enormity of this problem paralyze us, not with so much at stake and so many lives hanging in the balance, and notably, I would add, not in light of the analysis paralysis that we have stalled in over the past several years. Sentencing reform is a good, rational place to start. It defines the system, who's going in, for how long, and at what cost. Today in our Commonwealth, over half of those incarcerated in the DOC custody are Black or Latino. I implore my colleagues on the committee to pause and contemplate that number. Over half. Black and Latino residents in Massachusetts do not make up over half of the bad people in our state. Black and Latino people make up less than 1/5 of our total population as a state. What's more, while Black and Latino defendants make up a little more than half of those who are sentenced for drug crimes that do not carry a mandatory minimum sentence, they account for 3/4 of those sentences that do carry a mandatory minimum sentence. The clear bias in these sentences cannot be allowed to continue, particularly when study after study confirms that mandatory minimum sentences have shown no positive impact on public safety. Mr. Chairman, Madam Chair, these policies are abolic, something tried and disproved and best relegated to a closed chapter in our history. And they are not the only sentencing policies in that category. Low-level petty crimes like larceny and shoplifting fit the bill as well. They are crimes that without question warrant action and punishment, but they are also crimes that are committed at best out of immaturity and at worst out of poverty, desperation, and often addiction. A study by the DOJ in 2002 and 2004 found that about 1/4 of those convicted of property and drug crimes in local jails had committed those crimes to get money for drugs. And
Senator, I do want to set a good example for everybody because we have so many people here, so let's wrap up.
fair enough, I'll give you the high points. There is a wealth of information telling us that we need to update these, the thresholds for these crimes. We can update them to simply keep pace with inflation, and it would make a huge difference for making these punishments more proportional and observant of the public health components that we know will reduce their incidence. I think I'll skip over the quarry reform components of the bills, and you guys can study those at your, on your own timeline. And I'll close by saying this. This bill and the policies that we're seeking today are not about cutting corners or scrimping on essential functions of our criminal justice system. And I say that with confidence as a state senator representing one of the districts in the Commonwealth that is most heavily impacted by violent crime. If our current array of criminal justice policies we're serving the communities that are most heavily impacted by crime, I would be here defending them. But the bottom line is they're simply not working. We need to do things that are going to serve those communities right, that actually live up to the promise, and that stop doing harm to the very communities that we say we are trying to protect. So I urge my fellow committee members to consider these reforms not in piecemeal, but as a package that must be undertaken simultaneously if we are going to realize meaningful results. Thank you, Mr. Chair.
Thank you very much for your testimony. Representative Key.
Thank you, Chairman Brownsberger, Chairwoman Cronin. Through you to the members, I'm going to pick up two pieces of this omnibus bill, medical parole, and talk about the trust fund a little bit as well. So this bill contains provisions that would allow for medical parole in certain cases. Under the proposed program, correctional facilities could ask a judge to reconsider an inmate's sentence if they are terminally ill or dying. It's not only the compassionate thing to do, but it makes fiscal sense as well. Older prisoners are 3 to 5 times more expensive than incarcerated younger inmates. The DOC reports that at least $100 million a year is spent caring for terminally ill and dying inmates. So the federal government has also moved in this direction, and they've noted that the recidivism rate for this population is 3.5%. So take away that worry as well. A medical parole program wouldn't remove all of the spending that we spend here in the Massachusetts, but it is a smart approach on crime and would take away a large portion of the money that we are already investing in our communities. Lastly, I wanted to speak about the Neighborhood Safety and Opportunity Fund. All of the bills that we've put together in this omnibus bill are going to save us money, and therefore that's why they belong together. This would create this trust fund that would be targeted not only to people that are re-entering from prison, but as prevention measures within our communities. So we would be targeting dropout prevention, recovery programs, giving youth a second chance at academic achievement, job training programs, transitional job placement, pre-apprenticeship programs that earn a living wage. And also we'd have criteria in place that talks about how you can qualify for these programs. So not only, as I said, people re-entering, but victims of crime, veterans, those without diploma, convicted of a felony, unemployed, and especially targeting census tracts that have 20% of the population that falls below the poverty line. And so that kind of leads me to the next part of what I wanted to talk about just briefly. The initial concept of justice reinvestment was to help state government be more accountable to impoverished communities, mostly, though not exclusively, Black and Latino, where the burden of incarceration has been heaviest. There was a project by the Justice Mapping Initiative that identified these blocks as $1 million blocks because of the millions being spent each year on prison cells for high proportions of working male residents for an average of 3 years. $1 million blocks dramatize the trade-offs for specific neighborhoods between concentrated incarceration spending policies and focused investment policies that could yield greater returns in public safety, strengthened community institutions, and expanded neighborhood networks.
Thank you.
Just one last sentence. So when you look at these communities, what you see is that the predominant government institution that we are investing in is the criminal justice system. And the cost of that is taken away from our civic infrastructure of education, housing, health, and family. That is my district to a T. Not all of it, but the heart of it. And so I'm really proud to be putting this bill forward. I feel as though this is the best way I can represent my people. So with that, I'd like to turn it over to Ben Foreman from Mass Inc. Mass Inc. has done some incredible research that helped us understand where we're at here in Massachusetts. and he's going to talk about the geography of incarceration.
Good afternoon, and thank you, Chair Brownsberger and Chair Cronin, for the opportunity to testify very briefly in support of an Act for Justice Reinvestment on behalf of both Mass Inc. and the Massachusetts Criminal Justice Reform Coalition. There are many components of this legislation that we strongly endorse, including the elimination of mandatory minimums. We believe the preponderance of the evidence here suggests that these policies have been effective, and I want to turn your attention particularly to one recent study that looked at federal sentencing data and found when African American and white residents were arrested for the same crime, the African American defendant was twice as likely to be charged with the mandatory minimum. Now, of course, that could be the judgment of local law enforcement, but the point is the system never has the opportunity to hear that out and root out any potential bias. And they find that most of the disparities ultimately in sentencing originate from those cases where mandatory minimums are at play. Well, I want to focus mostly this afternoon on the Justice Reinvestment Fund because that's what's unique to this bill, and we believe it's integral to comprehensive criminal justice reform. As Representative Keefe noted, in a number of communities in Massachusetts, we're spending large sums of money. In Codman Square, $7.5 million a year. In Dudley Square, $4 million a year. In Upton's Corner, $3 million a year. That could be justified if it was increasing public safety, but there's also a strong body of evidence that in urban neighborhoods with high levels of incarceration, we've reached a tipping point where more incarceration is creating less public safety, not more. And in fact, that research has looked at neighborhoods in the city of Boston and found that they've crossed that threshold. We're currently in the process of mapping the city of Worcester now with data the Worcester County Sheriff provided, and we're seeing that same picture, which is really disheartening for us because Worcester is a stereotypical older industrial city. And tough on crime criminal justice policies that make it more difficult to participate in our economy can't be our response to manufacturing job loss and the resulting social and economic challenges residents face. Cities like Worcester need us to be smart on crime and spend our criminal justice resources well. Otherwise, we're going to wipe out all the gains we get from our very, very modest investments in economic development in those communities. And just to finish, the report that we released just the other week shows there's opportunity to reinvest funding. Between fiscal year 11 and 16, our correctional population fell by 2,900 individuals. And yet, our budgets for correctional facilities increased at $72 million above the pace of inflation. If we had just taken the variable cost savings that come from serving 2,900 fewer inmates, that would equal 600 treatment beds. Just think about what that means for a community like Worcester, where opiates have become a troubling antidote to the pain of lost economic opportunity. I'll submit my written comments that have the rest, but the only other piece is a reference to the state of Colorado, which has created a Justice Reinvestment Fund with bipartisan support. I think it's ours is a great model. And thank you to Senator Chang Diaz and Representative Keefe for their leadership on this legislation.
Thank you for staying so close to freedom. Okay. Yes.
Question, Mr. Chairman? Yes. Senator Chang Diaz and Rep. Keefe, thank you for your thoughtful work on this. Just a couple of questions regarding mandatory minimums. First, I'm just wondering if there's any implication for the mandatory minimums that center around operating under the influence of alcohol or drugs. We do have a focus now on treatment. Is there any thought, it has been discussion, that might allay the concern of people around mandatory minimums while operating under the influence of alcohol or drugs?
So I'll say that the provisions of the Justice Reinvestment Act do not propose to change those laws. The bill deals strictly with repealing mandatory minimums just on drug crimes, right? Not under operating under the influence.
And secondarily, just a question, having some familiarity with the mid-1980s when mandatory minimums were born out of frustration and disparity, particularly among law enforcement. How can we be sure going forward that this disparity that you have very well chronicled and that is very unfortunate, how do we not turn the clock back in disparities between individuals charged with similar trafficking offenses? We're not talking about possession, trafficking. How can we be sure that our judiciary our counterparts on the judiciary side make sure that there are fair and just sentences and not go back to those 1980s when the disparity created the need for mandatory criminals.
So I would offer a couple branches of reply to that question. One is that I think that sentencing guidelines offer an alternative to us as a state to capture the best of both worlds, if you will. I would also say that asking for on the front end a guarantee that any group of human beings is always going to make the right decision in every single solitary case, it is, that it's a fool's errand, right? We could ask the same thing about us as legislators, right? How can we be sure that the legislature will always make the best decision? We can't. In fact, we haven't for the last several years. But we have a judiciary for a reason. And that is for judges to be able to consider in their individuality the circumstances of particular cases. And the overwhelming majority of Bay Staters have affirmed that they would prefer to see policies that allow judges to make those individual judgment calls based on the specific instances of the case before them, and to not tie their hands.
Thank you.
Thank you, Representative Tucker. Any other questions? Thank you very much to all of the panel. Thank you so much. So I've got the group of panel DAs coming up. While they're coming up, I know that there are a lot of constables here to testify against House Bill 2252. I want to give you the opportunity at this moment just to, if you're a constable here to testify against House 2252, I want to give you the opportunity to just stand at this time to show that you're concerned about that legislation. Okay, so we've got a group of about 10. All right, so look, we're going to get to you, but I want to understand I want you to know what the sequence is going to be here. We're going to go through this collateral consequences testimony. We're going to do the DAs. I've got about 20 or 30 witnesses on collateral consequences, meaning all these things like expungement and fines and fees and all those things. That's going to be about 2 hours. Then I've got the next biggest group is juvenile justice. Then I've got bail. So if you're here for something other than collateral consequences, juvenile justice, or bail, I'm going to probably reach you around 4 or 5 o'clock. But you've risen, you put yourself on record as being concerned about the issue. We've received a lot of written testimony about the issue. We are definitely reviewing that testimony carefully. So I wanted to just let you know that we heard you on that. We will give you the opportunity to testify, but you're going to be after those large groups. So that's where we're at. Gentlemen.
Good afternoon. Great. Good afternoon. Tim Cruz, Plymouth DA. I'm here today with Worcester DA Joe Early and Norfolk DA Mike Morrissey.
Keep that murmuring down, please, if you can, please. I want everybody to be able to hear everybody's testimony.
And I believe that Middlesex DA Marion Ryan is en route. I know she was here a little earlier.
Okay.
And I just have just a brief statement to make, if I could. Good afternoon, Chair Cronin, Chair Brownsberger, and all the members of the Judiciary Committee. I appreciate this opportunity to speak to you today. My name's Tim Cruz. For the last 16 years, I've been the Plymouth County DA down in the Southeast Mass, and I want to thank you for this opportunity to talk to you today. I feel that it's extremely important to be here to speak out against the push to eliminate minimum mandatory sentencing for drug offenders. Minimum mandatory sentences are critical to protecting the public safety of all citizens. They are reserved for the small percentage of offenders who commit horrific crimes, homicide, certain gun crimes, sex crimes against kids, as well as drug trafficking. The legislature enacted minimum man sentences and placed the discretion in our hands, the 11 district attorneys who in conjunction with law enforcement work to protect public safety. I would say just 20 years ago, I've been a DA for 16. I was a defense attorney for 12, and I was an assistant DA for 4. If you go back in the time machine and talk about back in the early 90s, back when there was no uniformity in sentencing, no conformity or consistency in sentencing, when judge shopping was rampant back in our superior courthouses and district courthouses. This was so important for it to happen, to get that truth in sentencing, which we did not have for many, many years. You know, the first talking point many times that individuals looking to do away with the min-mans is that our state is in an incarceration crisis. That is not true. In fact, the Council on State Government Criminal Justice Review noted that Massachusetts was 49th in the nation with respect to our rate of incarceration, and our prison population continues to drop. Massachusetts is not in an incarceration crisis. And I'm not going to get into all the numbers, so I'm going to submit this same testimony if I could, but I do have some statistics regarding what the district attorneys talk about, what they undertook a review of certain criminal offenders. And what I would say that back in this review a couple years back, that 20% of the offenders had accompanying charges that involved violence of firearms. This is individuals, 1,400 or so, that we looked at in 2014. 20% of those individuals who were incarcerated in DOC for the governing drug offense had that gun charge with them. 74% of those offenders had a history of violence of firearms. And the inmates collectively, those 1,400 inmates, collectively had more than 54,000 arraignments, on the average of 40 apiece in our criminal justice system. We are now, as you all know, and you are all working hard, in the throes of an opiate epidemic as we've never seen before. We're dealing with opiate crisis all throughout the Commonwealth of Massachusetts. We see fentanyl coming now, and God forbid, I do believe we're seeing car fentanyl starting to show up also, and that is poison, and that is killing people. And there is no Narcan to save the individuals that are using that. Also in Massachusetts, we have reformed our minimum mandatory sentences just 4 years back, when we reduced the amount of drugs that was necessary in order to get the enhanced penalties, and also reduced the penalties. I strike that, increase the amount. And as a result of that, we've seen drug courts pop up all throughout the Commonwealth of Massachusetts, diversion programs dealing with the individuals who have the drug problems. The individuals who we are dealing with, the individuals who we are talking about, are people who are selling the poison, people who are trafficking in these drugs in our streets. You know, we've seen good things happen. In my own county, which is down the city of Brockton, our numbers have gone down incredibly amount by people working together. Collaboration, cooperation. Minimum mandatory drug sentences has been part of that great turnaround that we had in the city of Brockton. Last year we had 2 homicides. We normally, unfortunately, have 9 to 10. Last year we saw our gun violence go down 23% in 1 year. And that's from our information that we get from our ShotSpotter. We've taken successive prosecutions. Yes, sir. Thank you. And I'll put the rest in. Thank you very much, sir.
Mr. Chairman, Mr. Chairman, you going to say? Yeah, I'll say something. Mr. Chair, Madam Chair, and I'll be very quick. A lot of it's already been said. We're always willing. Also, myself, a defense attorney for 17 years prior to this job, we're always to work. I'm always working with Rep. Keefe, looking to do different things with regards to prevention and these type of things. Last year we had 215 opioid and heroin deaths. And it's typically the person who we see that gets sentenced on a minimum mandatory. Right now it's 15 out of 122 in the Worcester House of Correction. The person we typically see is the one who's trafficking. Trafficking fentanyl, trafficking in heroin. These are the people right now, like I said, 70 deaths. These aren't the users. These aren't the people who need treatment. These are the people who are bringing the poison into the neighborhoods and profiting off of that. Those are the people we're trying to stop. I'm always willing to discuss low-level offenders, always willing to discuss treatment. Those are things that the DAs as a group are always willing to discuss.
Thank you for the brevity of the testimony. Thank you. Appreciate it.
I will try to be as brief, Mr. Chairman. I would just add that I never thought I'd agree with Mass Inc. so easily that our prison population has dropped from 11,000 to 8,300 over the last 4 to 5 years. About 10% of those people are there on a drug-related offense. They represent on average of 40 arraignments per individual. Most of them, high percentage, have some kind of violent history, either committed with the sentence they're serving or on a prior count that they've had. 40 arraignments, so they're no stranger to the criminal justice system. Representative Tucker hit the nail on the head. I was here in the 70s and in the 80s. So when you talk about truth in sentencing, what is more truthful than a mandatory minimum where a person has a minimum sentence? It's good for the victim. Now, I'm not suggesting that there's some things that we can do to make things better, but we often exercise our own discretion. And when Mass Inc. says, well, they should have been saving $17 million in the prison system with a drop in population, we all know that that's really a fallacy because it's not a person-for-person savings. You have to continue to run those institutions. And that money is not available for the things that you probably should be doing. It's that simple. Money's tight. And if you ask us as district attorneys, we'd tell you very simply, we need some more beds for treatment. We need some more programs for people. We need post-conviction supervision. When we agreed last time to increase the weights and to reduce the time people would spend behind bars, it was all really conditioned upon what we thought we were going to get, and that was more help for people, especially as they came and were either in the system or reintegrating back into society. And there wasn't any. And so we obviously are firm believers in the sheriff of Norfolk County has one person right now, last year, one person serving a mandatory minimum. It's probably left over from a school zone case. Anybody else serving a mandatory minimum in that Norfolk House of Correction is either there because of a gun or a driving under charge. Now, I don't see any of you changing that, because you know how hard it was to do when we were sitting there? That's just not going to happen. And so to pick on the idea that the drug sentences are the low-hanging fruit just isn't true, and the numbers don't bear it out. So we hope that you will consider that when you make changes.
Thank you for your testimony. Stay with us for a second, please. Are there questions? Thank you thank you very much for coming. Oh, I'm sorry, yeah, Representative Deb.
Thank you, Mr. Chairman. Thank you, the district attorney, as well, for the work you're all doing. I have some questions, and I guess Mr. Attorney Cruz, some of the testimony you offered piqued my interest in this again. And you said that we put the discretion in the district attorney's hands on this end. And I come at this from a concern on the separation of powers argument, that the DA is supposed to have discretion to charge, right? And to me, the court system, the judges are the ones who are supposed to have discretion to sentence.
I'm going to give people opportunity to stand and show support of their positions, but I don't want to be these witnesses because they're not Go ahead, Representative.
Thank you. So the issue, I guess, and I had a privilege of serving for a brief time in Middlesex District Attorney's Office. We used, and I believe my colleagues last year when we were testifying on this, said that minimum mandatories are a tool for the prosecution, and it's an important tool to use. So that's a tool for prosecution, not a tool for justice to me. The question, you know, we have school zone charges, for example. We'd often break those out. We'd be very happy to get a school zone charge. We'd break it down in exchange for a guilty plea for a lesser sentence. So the question I had is, can we get numbers from you, from the district attorneys, on the number of breakdowns that we have, the number of breakdowns for minimum mandatory charges that go to then guilty pleas on lesser charges? I had a great meeting with sheriffs and asked them how many here, certain sentences, are here on breakdowns, and they said they couldn't give us those numbers. So can the district attorneys provide those types of numbers to this committee?
I think all those numbers would be available, if not through the DAs, through the trial court. I think they're all there. They would all be there from the initial charges brought to somebody. But you know, I think that when you talk about charging, yeah, that comes to the district attorney's office, because we are much like you. We're accountable to the public. We're accountable to the people we represent. I'm accountable to the 500,000 people I represent in the county every 4 years. So therefore, as a result of that, I think that the discretion should be with the district attorneys, the elected officials, the people who are going in front of the electorate every 4 years or every 2 years in your instance, to make sure that we can go forward in trying to keeping our people safe. And I think that we use it very sparingly. And I think that we've done that, and our numbers prove that. When you look at our numbers in Massachusetts, I mean, you're talking we're 48th or 49th incarceration-wise in the United States of America. I think we're doing it smart in Massachusetts. We're using it as we can to go after traffickers. There's nobody doing time for possession. It's not there. Marijuana was decrimmed back in 2008. Medicinal marijuana came in 2012. And we continue to have changes what's going on with the potential legislation. However, what I would suggest to you that the people that we're going after are the people who are peddling the poison, who are killing people on our streets. We have a responsibility to the people, our constituents that we deal with. And I think that's something that, as I know you guys also understand how important it is to deal with our constituents and try to get in front of that problem. So I would suggest that we should have that accountability, because we are accountable.
Thank you very much. Representative.
Just one brief follow-up. I think that answer, with respect, highlighted the concern I've got, that it's being motivated by political considerations. That the issue for me is, this is a job for a judge. And whether there's a criticism about our judges not taking this problem seriously enough and putting sentences below they should be, I don't think you can get any argument from anyone up here or in the body that traffickers should be sentenced to long terms. I think the concern that I'm hearing, or that I've got, that you seem to reaffirm to me, is that this is now an issue that's being done on a political basis because you're responsive to constituents.
This is
done. Have their role, which is supposed to be separate and apart from the
Correct. And 20 years ago, judges had this responsibility. When we had judge shopping, we had lines coming out of certain judges' courtrooms, and we didn't have that, which is why the people in the general public wouldn't understand. Back when Representative Morrissey was, well,
the 70s
DA
and
was.
80s. We made those changes. You as legislators have an important role in the criminal. You have legislators have an important role in the criminal justice system. This is your way to impact and to set the values of what the criminal justice system should look like. And when we made those actions, driving under is a good example. People were all over the road. Why? Because the judges, you served in the DA's office, you knew that you would wait for the right judge and you would kick the can down the field and you would torture the prosecutors and look for the right opportunity and get a soft touch. And people were sick of that. And so the response was that legislators said, and they put their imprint on, there should be a minimum for a certain type of crime. There's about 130 crimes that have mandatory minimums. Now, if you don't like what the judge is doing, try voting them out. Now, if you don't like what we're doing, you can vote us out. It's really that simple. You know, that we try to apply the law, we try to work with the legislature, because we know it's not an easy job. And at times, yeah, we do break cases down. And school zones, we were the ones who actually reduced the period of time and the hours. That wasn't an initiative by the DAs. So we recognized that it was probably being over-prosecuted or over-arrested on people to arrest the sentence out of someone. When it came time to return people's licenses back because they had a drug sentence, we were with it. I probably voted for it when I was sitting where you are. You know, it wasn't, you know, it sounded, when I sat there, it sounded probably like a good idea. And when I got in the district attorney's office, it made no sense whatsoever. And so when you take a look at it, you're trying to help people get them back into the workforce and to integrate it back into society, what was the sense of taking someone's keys away when it didn't even have to do with a driving offense? We were with you. So as a practical matter, you know, you haven't updated the sentencing guidelines in 20 years. And you're talking about all these things, about what you're going to let judges do, and you know, even giving people programs where maybe they can get some time off for doing the right thing and taking the right program. Sorry to say, you just don't have them. They're not in place. And you're going to remove the one safeguard that often protects the public on a sentence, on a truth in sentencing piece, a mandatory minimum sentence, and you're focusing on drugs because it's sexy. We are not the federal government. This system is obviously substantially different than ours.
By which you mean the federal government has a lot of drug offenders?
Well, they also they hit them pretty hard too, you know, so.
Okay, are there any Representative Barrington?
Thank you. My system here. Thank you for your hard work, and obviously we 100% agree with you that the opioid crisis mandates tough requirements for sentencing with regard to the traffickers. The question that I have for you is, because the statute, as it's now written, it deals with those who manufacture, distribute, dispense, or possess. So my question is, are there any crimes at this point that you would say, I know you said no one's in mandatory minimum sentence because of that, would you be amenable to taking that, amending the statute to just take out possession?
Oh, go ahead.
We're always amenable to working with the legislature with current changes. You know, for example, the school zone, it was mentioned, we expanded the distance because a lot of people were getting charged. Anywhere you went in the city or town, we're always amenable to working with the legislature. And on the back end of it, you know, many of us, myself in particular, a sentence, for example, 2 years to 2 years in a day, I hate. Why? Because it gives the inmate no hope. It doesn't give them an opportunity for good time. It makes it harder on the guards at the jails. They don't get involved in AA, NA programs that can get them out sooner. We're always amenable to working with you.
I think it says possession with intent is what the figure says. Am I correct?
With intent, right.
Yeah. So therefore, that's
possession. Mere possession.
Yeah, not strict possession.
So plain possession.
Right. Strict possession is not a jailable offense. Yeah.
Okay. Thank you. And thank you because you work with the drug courts.
Thank you.
Drug prevention and mental health courts.
Sorry, Representative Farrell, it's your question.
Thank you, Denise. I have a quick question. When we look through this entire bill and we look at the areas, are there any specific areas indeed that we felt that we couldn't compromise on?
Which bill are you referring to?
Obviously we like more programming and more opportunities. I mean, more beds for diversion and more programming when people are incarcerated, and more post-supervision conviction help, you know, people getting out. Those are all things that You know, we don't want to see the same people either, by the way.
So you mentioned only 10% of the incarcerated population are drug-related. It seems, from what I hear, and again, I don't have anecdotes and some information, but you have the specific facts I would gather. Is that specific charge, or typically you would see people committing crime and charged for something that they are drug involved, and that's the reason for their criminal activity? Do you include that in your 10%?
The 10% are people that would have a 94C drug charge. Now, they may also have something else with it, but the drug charge is one of the things in which they were sentenced on and getting time for. So there are people, I'm sure, who may be serving time and may have a drug or an alcohol issue that may not have been charged on it, but not included in that total.
And if I may, where we could work with you, there's a couple of very interesting programs. We recently had Sam Quinones, the author of Dreamland, came out to Worcester. And oftentimes you hear, we can't arrest our way out of the problem. But what Mr. Quinones said, and it's very interesting in terms of we have a substance abuse disorder that only 10% of the people who are addicted to opiates are actually getting treatment. They've done some things in some of the counties. We're currently working with our sheriff in Worcester to take a look at it. But for example, up in Essex, they made one wing of the jail into a detox. They made it a detox. So the people are in AA, they're in NA. And these are the people who the police, the fire, the EMTs are Narcaning 2, 3, 4, 5, 6 times a week, and they're just getting frustrated because you can't get them held on a Section 35. But that might not be the best answer. The best answer might be taking a wing at the jail, taking out the violent offenders, take the people who are in there on gang crimes or sexual crimes, and just make it opioid and alcohol, and treat them from the day they get up in the morning till the time they go to bed to deal with that problem, to deal with that dependency, not just, for example, going into a day room, sitting on a sofa and watching TV, but actually helping them so that they don't become that 40 or 75% recidivist within the next 3 years.
Any other questions for this panel? Thank you so much, Charlie.
Thank you.
Appreciate it. Thank you. Next on the list, I've got Representative Senator Eldridge. Did you have anything else you want to bring up?
Hoping to bring forward just the harm reduction crisis members to testify on the few priority bills.
Yeah, okay. I'm going to ask, and I'm just going to say this in the room, as you're going out of the room, if you end up out in the vestibule, let's keep that a quiet place as well, because the noise system can make it hard for people in the back of the room. Pass it on.
So good afternoon again. I just want to say for anyone who's a member of the Harm Reduction Drug Law Reform Caucus is welcome to stand behind us to move this process forward more efficiently. I'm State Senator Jamie Eldridge, serve as the Senate Chair of the Harm Reduction Drug Law Reform Caucus. Thank you so much for taking us out of turn. Here with Representative Paula Hero, the House Chair, and Representative Mary Keefe as well. I'm going to highlight 3 bills. I just want to say very briefly, the Harm Reduction Drug Law Reform Caucus has existed for 4 years, and in that time, what we have realized is that the public is supportive of comprehensive criminal justice reform. The Harm Reduction Drug Law Reform Caucus has 60 members. It is a bipartisan caucus. The media is focused on this. It is time for comprehensive criminal justice reform, whether you're talking about reducing mass incarceration, whether you're talking about fixing our broken judicial system, alternative justice, or diversion. The first bill I wanted to talk about is an act promoting restorative justice practices, which I have filed with Representative Sean Garbely behind me. It's a diversion bill that would create a local option statewide. It is mirroring the program that Middlesex DA Ryan has created with Communities for Restorative Justice. She will be testifying with the panel later. The bill creates a formal restorative justice program for juveniles and adults within the existing criminal justice system. We have a credible number of police chiefs who have endorsed this bill. What referrals to a restorative justice program would divert someone who is arrested for a crime that prosecutors and police, with consultation with the victims, agree that a diversion is better to avoid someone getting a fine or a record or an arrest record that could harm them going to college, getting a job. So this is part of, I think, diversion and avoiding the mass incarceration system that we have right now. We've had input from the Mass Trial Court, Middlesex DA's office, the Restorative Justice Coalition, and police chiefs. The other bill I want to talk about is an act reforming pretrial process, bail reform. We miss Senator Ken Donnelly for so many reasons. This is one of the reasons we miss him. He has been a leader. He was a leader on bail reform during his time as a senator. Representative Rogers has also filed this bill, House 3120, Senate 834. The bill would establish an informed and objective risk-based release system. We know that bail decisions are intended to be made based on the likelihood of a person returning to court. But instead, whether you are released or not on pretrial is often decided by your ability to pay the amount set by a judge, which I would argue is arbitrary. A wealth-based system keeps people in jail when they could otherwise safely remain in the community while awaiting trial, therefore saving all of us money. And I also want to mention a bill that was filed by Senator Brownsberger, an act to reduce the criminalization of poverty, Senate 777, House 2359, also filed by Representative China Tyler. The bill reduces the volume of prosecutions for non-driving related license suspensions, as well as the number and money amount of fees exacted on people who are indigent was a significant barrier to people being able to get back to a more productive life. Now we're going to have Representative Perot talk about the rest of the caucus priorities.
Thank you for justifying time.
Yes.
Thank you. Thank you, Mr. Chairman and Madam Chairman. Through you, thank you to the committee. My name is Paul Hero, and I'm a state representative from, my name is...
How you doing back there? Can you hear him?
No.
Yeah, just
I'll hop right into it and do the best you can. Okay, my name is Paul Hero, and I'm a state rep from Attleboro. And prior to coming to the legislature, I worked in the Mass Department of Correction as the Director of Research, and I worked in the Philadelphia jail system as Assistant Commissioner. I'm also a criminologist by training and practice. And I'm going to talk about a couple different bills, and I want to talk about these from sort of an academic point of view, though, to kind of frame this in social science research in a way that we can and should go forward thinking about these different issues. So the bills that I'm going to talk about are relative to juvenile expungement. We have House 2309, Senate 944, which is an act relative to the sealing of juvenile records and expungement of court records. We also have House 3126 and Senate 845, which is an act relative to the expungement of records of persons falsely accused. And also an act restricting fine time sentences, which is House 3077 and Senate 755. The couple of different points that I want to talk about, though, is why do we have a criminal justice system? And if you look at the social science research, you can come up with 5 general reasons why. And everything sort of falls under these 5 general reasons. You have general and specific deterrence, you've got incapacitation, you've got retribution, and you have rehabilitation. So with respect to the bills that I just described, if we think about these, if we consider something like fine times and the idea that we have to give somebody, if somebody has a bail that they have to pay in order to be released from their hold, pre-trial, having that fine, that bail doesn't really support any of the 5 reasons why we would have criminal justice. You may say something to the effect of, the argument could be made that somebody could be deterred, either as an individual or generally, but then we have to look at other social science research, criminology and sociology, and that is that the certainty of punishment is a lot more important than the severity of the punishment. So this whole, when it comes to these, fines, they're really not supported by any of the 5 reasons what we're doing with criminal justice. With respect to juvenile expungement, it's the same thing. None of the reasons why we have a criminal justice system, the 5 reasons I outlined, none of those are actually supported by the social science research. I'm running out of time, but it's never uncharacteristic of me to say something provocative, but I'll switch over to mandatory minimums really briefly. And the panel that spoke just before us is rather cherry-picked and ill-informed a lot of the things we were saying. One of the things they mentioned was that the drug population has decreased down to, the DOC population has decreased down to 8,400, but I think that was sort of intentionally omitting the pretrial and the civil commitments, because the population is not 8,600, it's actually 9,400. And that's only down from about, just over 10,000 back in 2005. So there was a lot of cherry picking with the data there, and ultimately mandatory minimums are intended to be used as a tool to force a plea bargain. So with that, I'd be glad to take any questions.
Thank you very much. Any questions from the Any members of the Harm Reduction Caucus that have not spoken already would like to take this opportunity to address the public or committee? At this time, Senator Jailer.
Thank you, Mr. Chairman, and thank you, Madam Chair. Happy to see you. Three of us are here to talk particularly about bail reform, Senate 834. There are two problems with our bail system. First, it locks up thousands of people who are not flight risks. And second, it doesn't ensure that people who are not likely to show up actually show up for trial. In almost every county, there are more people locked up awaiting trial than have been sentenced. Both DOC and the Middlesex County have seen an increase of 23% in the number of pretrial detainees. We hold about 5,000 people every day awaiting trial. 25% of the incarcerated population has not been found guilty. Reforms to the pretrial process that we are presenting could result in the biggest criminal justice reform that we have been discussing. This pretrial incarceration system results in about $200 million a year in spending, and it results in a significant cost to the individuals who may lose their jobs, their homes, their families, and their future employment. At the same time, the current bail system has a high rate of defendants who do not show up in court. So our system does little to guarantee that the person who gets out on bail will follow through and appear in court. It discriminates between people who don't have money and people who do have money. In addition, decisions on bail are often made with little information. So this is a comprehensive set of reforms which I will not describe in detail, but it provides for more risk-informed decision-making, better release conditions, and moves the state away from a cash-based system. Similar reforms in dozens of counties, the District of Columbia, and 6 other states have led to significant reductions in the incarceration of defendants before trial, as well as increases in the appearance rates of defendants in court. I hope you will give this well thought out and comprehensive bill a favorable report. Thank you for your attention.
Thank you, Senator Jailer. I know Representative Rogers is here in support of the same issue.
That's right.
Thank you for your support on that. Anybody else want to weigh in on anything particular? Representative Livingstone?
Actually, the same bill which I filed with Representative Rogers. Just a quick story. When I was a district court prosecutor, as I know some of the people here were, and the information you had was typically just the Board of Probation record, the police report, and nothing else about the defendant. And that you couldn't make an informed decision. Whereas we had a risk assessment tool, we could make a better decision on when people could come back. Also, if we created the Division of Pretrial Services within probation, monitoring people better and encouraging them to come to court. I found as a prosecutor that often the defense counsel's diligence had more to do with them returning to court than anything else. And I think that type of pretrial services would definitely encourage people, get more people to come to court without the need of locking them up, which has such detrimental effects. Thank you.
All set? All right, Cal, thank you very much for your support and work on these issues. All right, moving on. So next, I've got a couple of judges. Judge Journal and Judge Craftley are present. Am I right? I'm going to call Representative Linsky next. And after this witness, I'm going to call Representative Linsky, and then I'm going to swap back and forth for the list. I'm going to judge Representative Linsky, Senator Shortly, and Representative Barber as well. Representative, I did say your name. Maybe you didn't. Gotcha. You're on.
All set? Okay. Good afternoon. My name is Paul Chernoff. I am a former chairman of the parole board, former district court judge, superior court judge, and at this juncture I am doing mediation work for the courts and also am a volunteer attorney for Veterans Legal Services. It's a small portion of the puzzle that I'm here on today, and that is the Corey bill dealing with the resisting arrest. I and Judge Kratzley, to my left here, are volunteers at the Bedford VA, and we represent veterans at their legal clinic. We see many veterans who are people who are from the battle zones in Afghanistan and Iraq, and when they come home for the first year or so, many of them have a great deal of difficulty being reintegrated into our society, and they get into relatively minor problems. One of the problems they get into is resisting arrest. What happens with so many of these people, after a year or two or three or four or five, they really settle down and they're doing well. They come in and they see Judge Kratzley and me. It's 5 years after their resisting arrest conviction in court, and we tell them, sorry, the law is that this can never, ever be sealed. And it seems to me that that is a tremendous injustice to people. The law, resisting arrest is not a crime against moral turpitude. It's not a felony. Clearly, it's an important part of our system for policing, and it protects the police and the public and perhaps even the individual. But it seems to me after 5 years, we can say to a veteran and to other vulnerable people that the crime can be sealed. It's a misdemeanor. And I, on behalf of, as I say, the war veterans whom I see on a monthly basis at the Bedford VA, and on behalf of other vulnerable persons, feel that the resisting arrest should be changed to the category of crimes that can be sealed in 5 years. Thank you.
Thank you very much, Your Honor.
Yeah, my name is John Kratzley. I'm, like Judge Chernoff, excuse me, a retired judge from the district courts, Roxbury District Court, followed by Suffolk Superior Court for over 20 years. And I, like Judge Chernoff, have been through the Access to Justice Fellows program at the Supreme Judicial Court, a volunteer at the Bedford VA. And the veterans that we have seen have brought both of these sealing issues right forcefully to our attention. The one that Judge Chernoff mentioned on resisting arrest is the first, and the second is another that I know is in front of you for change, and that's the larceny threshold number. Several of the veterans that we've counseled have had larceny convictions just above the 250 threshold. Larceny convictions at 350, 400, shoplifting situations, and yet that's not sealable for 10 years. And so I know others who are promoting Corey reform are similarly promoting changing the threshold number for larceny that creates the felony and therefore the 10-year sealing problem. I also know you've got proposals before you to even lower those year numbers for misdemeanors and felonies, but certainly the larceny threshold is no longer, it seems to me, realistic. The second, while I'm up here, if I can, is to talk about the restorative justice legislation that I know you're going to hear from a number of the police that are here today. I know you're going to hear from District Attorney Ryan, but I am on the board of our local restorative justice program in Concord, C4RJ. It's a police community partnership that allows selected offenders, with the cooperation of their victims, to go through a circle process that's much, much more intensive, much more challenging, it seems to me, for the offender in terms of what they have to confront about themselves and about their victimization that they've done to the victim than anything that I can remember from the formalities of the court. Now, these are selected cases. The cooperation of the district attorney and the police and the victim make them go forward in this manner. But what's important in the legislation that's in front of you is that instead of remaining a community program, it would be available court-wide. It would be integrated into our court system and available at arraignment, available on pretrial probation, available as a condition of probation. It's just a smart thing to do in the diversion field to move restorative justice into the court system. Thank you very much.
Thank you for your very kind testimony. Other questions from the panel? Thank you very much.
Where would I submit my? Good, great. Thanks.
Representative Linsky. I'm going to call Representative Barber next, and then Senator Green. Representative Linsky.
Thank you very much. I'm going to be brief, and then I'm going to join a panel after this. But I want to talk about two small bills. I understand. Thank you, Mr. Chairman, Madam Chairman, members of the committee. I'm going to talk about two small bills that haven't been mentioned yet. And the first bill is House Bill 883, an act relative to indigent defense counsel. This is a bill that I filed after an exhaustive post-audit and oversight study and report that we did about 2 or 3 years ago that addresses the issue of the escalating costs of providing indigent defense counsel on misdemeanor cases in the district court. We all just finished our respective budgets in the House and the Senate. We all grappled with the issue of the literally now hundreds of millions of dollars that we're spending every year on indigent defense counsel. There exists a statute in Massachusetts that allows a district court judge on misdemeanor cases to not have to appoint counsel if there is no possibility of incarceration. That statute has been on the books for quite a while. Unfortunately, it is never, ever used. And as a result of that, in 23 identified misdemeanor cases where counsel is routinely appointed, it costs the taxpayers $4 million or $5 million a year, despite the fact that everyone in the courtroom knows that there is no chance of incarceration on those cases. My bill 883 changes the presumption whereby incarceration could still be possible, but the assistant district attorney or prosecuting officer would have to affirmatively state that they could be seeking incarceration, rather than having the current presumption there being that there would be incarceration. That simple 3 or 4 word change will save the taxpayers of Massachusetts $4 to $5 million a year. I'm happy to provide the post-audit report that we did. It is one step that I would suggest this legislature can take to start addressing the real problem we have. We know that we have to do sub-budgets several times a year for CPCS costs, and I'd ask that this committee to take a good, long, hard look at 883, House Bill 883. The second one is, again, a very small change. House Bill 890 is an act relative to criminal background checks for youth program volunteers. As we all know right now, if you want to be a youth coach, a soccer coach, a little league coach, you need to get a query check done. The problem is, in order to physically get that done, the local police departments aren't able to do it. This would allow local police departments to do that rather than the Board of Probation on a voluntary basis. It wouldn't force the police departments to do it, but it would give them the option to do it. It would be very helpful in small towns. The police chief in Sherburne brought this to my attention, and quite simply, it's a way of saving both time, money, and effort for a lot of youth organizations and PTOs such as that. I thank you for your consideration on those two bills today.
Thank you for your testimony. Any questions? All set. Thank you very much.
Thank you.
I said Representative Barber. Did I say that? All right. Okay. My word here.
I will be extremely brief.
Thank you.
And I'm joined with other members of the Progressive Caucus. Thank you, Chairman, Chairwoman Cronin, and esteemed members of the committee. I appreciate your time and your commitment to looking at criminal justice reform this session. With the opportunity, we can address the social and class disparities in the criminal justice system and also spend our state dollars more effectively. efficiently. So I'm joined by a few intrepid progressive members of the Progressive Caucus who have stayed here for the hearings. And like my colleagues, I've co-sponsored a number of the bills before you, and I'm not going to take up too much of your time. We've submitted a number of comments in writing. I want to briefly talk about two bills today, and you have heard about them, so I'm here just to put in my support. And one is House 2309. This is the act about sealing juvenile records and expungement of court records, filed by Reps. Khan and Dykema. The bill, of course, allows for the sealing of juvenile records after 1 year without a second offense and expungement for juvenile offenders after 3 years without a second offense. Criminal records are one of the top barriers to reentry, especially for young people. They not only affect jobs, but also higher education and financial aid. So this bill is a critical step in helping young people get their lives back on track. The second bill, which you've heard quite a bit about, is House 3120, an act reforming the pretrial process, or bail reform, which of course shifts Massachusetts away from a cash bail process to a more equitable risk-based assessment. So because of cash bail, we're more likely to have low-income folks in jail for pretrial offenses, and they often lose their employment and have trouble with taking care of their children during the process. On behalf of the Progressive Caucus, we strongly support these two bills and are happy to work with you as these move through the legislative process, and happy to take any questions.
Thank you very much for your efficient testimony. I do appreciate that. Any other questions from members of the panel? Thank you for going on record.
Thank you.
Thank you.
D.A. Ryan. And after D.A. Ryan, I'm going to get Senator Green and Representative Carvalho.
I'm joined by Representative Livingstone on House Bill 874, the act relative to costs of appeal. This is a bill that is just a grant of immunity. I'm sorry, 897, grant of immunity. This issue speaks to something that changed a few years ago, but did not change far enough. A number of years ago, the immunity being given to a witness who claimed a privilege against self-incrimination was removed from the sole jurisdiction of the Supreme Judicial Court and vested in judges, particularly of the Superior Court. So a judge hearing a trial who was most familiar with the case, a witness asserted a Fifth Amendment privilege, that judge could then grant immunity to that witness and have the witness testify. That protection has not been afforded to the juvenile and the district court. So the choice is now a case in the juvenile court or the district court where a witness, either for the prosecution or the defense, wishes to assert a Fifth Amendment privilege. That judge cannot grant immunity. So that testimony does not become a part of the trial. It may well, and the real practical piece of this is cases should be tried in the court best equipped to serve them. We should not be in a position where a witness's testimony is so critical that they need a grant of immunity, and the case might perhaps be charged in the Superior Court that could otherwise perfectly well be tried in the juvenile court or the district court. We're going to the Superior Court only because the Superior Court judge can give that grant of immunity. So this is really a practical change that allows us to better use our resources and allows the judges who are best suited to handle a particular case, particularly for juvenile cases, to be able to do that.
I just want to echo what D.A. Ryan said. I know it's limited for time, and filed this piece of legislation as well as House Bill 896 that deals with the same exact issue.
Thank you very much.
And similar to that, I also have House Bill 897, which speaks to a witness who has been given a grant of immunity. Now in Massachusetts, if you're given the grant of immunity and compelled to testify, and you still elect not to testify, the maximum sentence that the court can impose is a 1 year in the House of Correction. That sentence to be imposed should be commensurate to the kind of offense which you're obstructing. Obviously, if it's a homicide trial and a witness, either a prosecution or a defense witness, refuses to testify, they can do so with a really knowledge that the penalty will be relatively small. And thus, evade justice in terms of the trial being able to go forward with that testimony. It's in the public interest always to have everyone who has information to give to the court be testifying. This would change that and put in place a sliding scale of punishment that would be proportionate to the offense about which they were being asked to testify.
Thank you. Any questions from the panel? You're around, we look forward to reviewing all of these issues.
Thank you.
You have one?
Yes, I do. I have several more, but I also have the panel here on the restorative justice measure. But I can speak to the act relative to victims' rights, which is House Bill 709. That is a bill which deals with something that's recently gotten some public discussion, which is the abatement ab initio provisions. That which says that if a defendant dies during the course of his appeal, in Massachusetts now, the appeal is automatically dismissed, the conviction is overturned. There really are three competing interests when you have that situation. You have the interest of a victim or the victim's family who, after a long process, has gotten to a conviction, wants to maintain that conviction, both for what it says about what took place to them, as well as the practical considerations. Having that conviction may be helpful to them either in getting restitution or in a civil suit. So there's that interest. There is also the interest that we all hold very dear, which is that no conviction is final until it has been fully appealed. So we want there to be a full appeal. And thirdly, there is a public interest, which is if something has gone awry in the process, because that's what the appeal is, somebody's claiming something went wrong at their trial or in the course of their criminal investigation. We want the appellate courts to look at that and tell us if that's right or wrong. And if it's wrong, let's not keep repeating it, and how can we do it differently? So what this bill would allow us to do is start taking that more thoughtful approach of many states which have looked at this and say that if someone dies, regardless of how they meet their death, during the time they have an appeal pending, that appeal would not automatically be dismissed. It would go forward, substituting for that defendant either their next of kin or their executor of their estate. It would allow the appeal to go forward, the conviction, if it's upheld, that's a benefit to the victim or the victim's family. If the conviction is overturned and we're given additional guidance, that is helpful to the public. So it really is the trend in so many other states that have looked at this, not to be so quick to just dismiss the appeal. And you may be, and also just in terms of resources, you could be at a point where perhaps the case is already scheduled for argument at the Supreme Judicial Court. Someone dies the day before. We would never hear those issues. So this is really just a practical way to implement all of that.
So Madam DA, I hope you won't take this disrespect if I ask you to abide by the 3 minutes.
Yes.
I'm holding everybody else to.
Yes. Does the committee want to hear from the panel who's here with respect to the restorative justice bill?
I'm struggling to keep things in order here. The order I've announced, which is going to live by, is we do the collateral consequences.
That's fine.
Then the juvenile, then the bail, and that's the order. So honestly, if you're here for something other than collateral consequences, then juvenile justice, then bail, you could come back at 5 and it'd be a good time to do that.
And I am here with respect to House Bill 874 and 907. I'm happy to submit written testimony on those. Thank you.
Thank you.
All right, I'm going to do Senator Green, Representative Carvalho, and then I'm really going to try to narrow zero in on this list too.
Thank you very much, Mr. Chairman, Madam Chairman. I have 11 bills here, but I promise that I'm not going to speak about all of them. I appreciate the opportunity to speak today. So the first bill is Senate 816. I've chosen a few that I think really raise to a different level. That's an act expanding juvenile court jurisdiction. It increases the juvenile court jurisdiction to age 21. So that young people who get into trouble will be treated by a developmentally appropriate system. With recent court decisions recognizing how different the juvenile thought process is from adults and how the brain continues to develop long after an individual is 17 or 18. It is critical that the juvenile justice system recognize this scientific fact. We successfully all raised the age to 18 a couple of years ago, and based on the success of this, I would ask that we further increase the age to 21. The Juvenile Court and Department of Youth Services are uniquely qualified to handle this age group, and this change will improve the outcomes for that population. The next bill is Senate 817, an act relative to testimony in criminal proceedings. It protects parents from being forced to testify against their children, called the parent-child privilege. The current law protects children from testifying against their parents. Why not have the same law protect parents from testifying against children, particularly in an age where we want to have children talk to their parents, get advice from their parents. By not allowing this privilege, we stifle that family contact. I hope that we do that this term. The next bill is Senate 821. That's an act relative to criminal forfeiture. It's a new bill for me. It would implement stricter guidelines for police permanently taking personal property in Massachusetts. Under current law, the police may seize property if they suspect the property was connected to a crime. The law also gives police a powerful incentive to take property because they keep some or even all of the forfeitures proceeds. The Institute for Justice, in its national report on civil forfeiture, graded Massachusetts and North Dakota an F because of the fact that we have this. So what I'm saying is, if somebody is, you should not seize their property prior to the fact that they've been convicted. But to just take someone's property without due process is not the right thing to do. The next is an act relative to law enforcement access to communication records. It makes a correction to the recently enacted Jessica's Law, which created new enhanced penalties for sex offenders against children. This law allows DAs and Attorney General to use an administrative subpoena process. That would be doing something without going to court, showing probable cause, and getting permission. I'm asking that that not happen unless it was clear that there was a sex offender issue. Thank you very much. I've tried very hard as a previous chair, and I respect so much the time that you all put in. Thank you so much.
And we have great respect for your basic knowledge and initiative as a former chair. You bring so much to this team. So we look forward to working with you on many of those.
And I'm glad to answer questions. I assume no one has any. Thank you. Thank you.
Thank you, Madam Chair. So Representative Cavallo, yes. Do you have something with you?
Yes. Thank you, Mr. Chair. Now begin. Good afternoon, Mr. Chair. Good afternoon, Madam Chair and members of the committee. It's good to be on this side for once on this committee, so I feel the pain. So I'll try to be as brief as possible. I have three people that will testify with me on behalf of Bill number H3037. It's not a new issue to you because you've heard many folks talk about it today already, which essentially raises the age of juvenile jurisdictions to include 18, 19, and 20 years old from the system, to include in the system, and also raises the age from 7 to 12. Right now, kids as young as 7 years old can be arrested and charged with a crime and convicted. The other portion of it, again, you've heard it, but it deals with the sealing, improving sealing opportunities, as well as creating opportunities to expunge those records. And finally, has a commission to monitor the data collection, essentially, of this bill. And I filed this bill on behalf of Citizens for Juvenile Justice, the team leading the way, as well as the Future Movement, which is based in actually my district. In my district, as many of you know, I represent parts of Boston, Dorchester, and Roxbury, 5th Suffolk, and you heard from Mass Inc. in terms of who are in the House of Corrections, particularly in the Suffolk County. Those folks, Dorchester, in fact, I think the man mentioned Upton's Corner, which is exactly where I currently live. So my position on this, and the reason I'm on file this bill, particularly on their behalf, is my district is 94% people of color, right? And when you think about that alone, and who are in jail, in terms of what Mass Inc. has done in terms of their data, with 46% of the people being in jail and house, I believe, at least in Suffolk County, are black and brown. And actually, my district has a high percent of young adults. I have 30% in my district of people in that age bracket, versus I think across the state is more 20, 16, and 10 in some other parts of the state. So it's my duty, I think, I believe, if we can include some of these individuals in the system, in the juvenile system that we know works better than the adult system, that we know that they have training, they have GED programs and so on. It would be better for those young adults so that later on in life they're not in the system. So those are the quick reasons as to why I particularly filed this bill, but I'll let the experts that I have with me talk more about the bill. And I have Leah Chester, who's a research fellow from Harvard Kennedy School of Law, School of Criminal Justice Policy. I also have Jotam Zaire, Director of External Affairs at ROCA, which is a wonderful organization that does great work with our youth. And I also have a retired judge, Superior Court Judge James McHugh. And I have Greg Courteau, who's from UTEC, who I think needs no introduction himself. But without further ado, I'll let them come and one by one. Maybe we'll start with the judge first, and then we'll go down.
Good afternoon, Mr. Chairman, Madam Chairwoman. I'm here to support this bill. I'm here to support raising the age to 21, the age of juvenile jurisdiction to 21. And I frame the remarks by the young man we heard now a couple of hours ago who said that he became involved with the criminal justice system when somebody looked at him funny, so he punched him. And it seems to me that's the kind of impulsive behavior that science has shown us continues with young adults as they emerge and become full adults. And therefore is a strong incentive for thinking about and executing a program and a protocol that would keep those people under supervision where they can get the help and training and encouragement that they need in order to become useful citizens. They're all going to get out. They're going to get out after relatively short terms, and it seems to me that a social investment that gets them out far better than they went in is an enormous benefit to us all. That can be done without any adverse impact on public safety. The judge under the juvenile justice system has expanded, still has the opportunity to deal, the district attorney first of all, has the opportunity to charge a person as a youthful offender. If there's a conviction, the judge can sentence that person as a juvenile, sentence him or her to a juvenile term and a suspended adult term or a straight adult term, depending on the circumstances of the case. You simply raise the age limits by 2 years. You do this gradually. You have a chance to see how it works. You create a commission to look after it and to find out what's working and what isn't working and report back to you. And together we go forward to try to make this, as I know all of you do and all of us do, a better world for us all. Thank you.
Hi, good afternoon. Again, I'm Leah Chester. I am a research fellow at the Harvard Kennedy School's Program in Criminal Justice. And I'm here to give you just some brief highlights on the research of emerging adult justice. But I want to note right up front that providing effective and developmentally appropriate responses to this population is a particularly promising way to substantially improve public safety. Not just that you won't make it worse, but in fact, you'll make it substantially better. Society has long struggled to determine what is the moment a child becomes an adult. When the juvenile court was first established more than a century ago, we settled somewhere between 16 and 18. And as some of you will remember, in 2013, this legislature passed a law in Massachusetts to increase it to 18. It turns out that there is no magic birthday. That over the last couple of decades, we've benefited from a substantial body of research, especially in neurobiology and developmental psychology, that shows that development is a continuum. 18 and 19 and 20-year-olds are right in between that continuum, between a dependent, immature child and a fully independent, mature adult. They share many of the traits of their younger peers. They are volatile, especially in emotionally charged settings. They're susceptible to peer pressure. They're risk takers, impulsive, less future-oriented. All of those factors are further enhanced if you have a history of trauma. This is a population with a substantial history of trauma. Their brains will not be fully developed until their mid-20s or later. There's also sociological research I find particularly compelling and informative, and that is that this transition to adulthood has become prolonged. This generation is reaching those developmental markers that bridge into adulthood much, much later than the prior generations, and that's usually marriage, steady employment. Those are those kind of bridges that you see that will age you right out of crime. I don't want to scare too many people in the room that are parents, but in 2016 there was a study at the Pew Research Center that showed that 32% of 18 to 34-year-olds live at home with a parent. I think that is very indicative of where we are as a society. And some 18, 19, 20-year-olds are largely dependent on their families. I'm thinking financially, emotionally, and practically. But unfortunately, our justice system does not recognize this developmental distinction, right? 18, 19, 20-year-olds are automatically lumped into an adult system with people all the way up to geriatric age. The results are poor. You've heard it a number of times. I don't think I need to repeat it. But 3 out of 4 of emerging adults released from incarceration in Massachusetts will be rearranged in 3 years. They make up a disproportionate share of those arrested and a disproportionate share of those incarcerated, and they have the worst recidivist rates. I just want to end to say there is some good news, right? Don't want to leave you in the lurch, and I have a prop, as always in academia. Most young emerging adults will age out of crime. By about age 25, there's a distinct drop. This age, this is the risk-taking age, is also a tremendous period of growth and opportunity. Peer pressure can be negative, peer pressure can be positive, right? This is what we're looking at when we send our kids to college. We recognize they're not fully mature. We are trying to give them that positive peer pressure. So I just would say that you have many of the elements that research shows is so effective in helping kids age out and having those positive opportunities. They exist in the juvenile system, and there's every reason to believe in the research that this would dramatically improve your public safety. And you're not alone. Illinois, Connecticut, following closely behind. Europe has been doing this for many, many decades to great success.
Thank you. By the way, while the next person is coming up, why doesn't somebody else hold the rest of the group can see what you're showing us? Yes, sir.
Hi, my name is Yotam. I'm coming from Roca. We have the privilege of working with 700 young men who are very involved in the criminal justice system every year. And we're here to support also this important bill to raise the age of 21. I think the most important word that you are likely to hear today is recidivism, because this is the word that means that something that we're doing in our justice system is not working. The response that we're giving to some kind of criminal behavior is not effective because people are coming back. And you all know that recidivism rate is the highest among young adults, and we were very troubled by it as well because we work with a lot of young adults every year. What we did when we realized that is that we convened a large group of a lot of our partners here in Massachusetts to look at all the science that Lael just mentioned, a lot of policy options that other places are trying, and a lot of the experiences of the leaders of our criminal justice system. And we created a laundry list of all the options in policy and responses that people can do with this specific age group of 18 to 24, and particularly the younger cohort among this group, 18, 19, and 20 years old. And we looked at this list, and we looked at it again, and then we realized at some point that about 3/4 of the proposals in this list are already happening in our justice system in the juvenile court. And that instead of creating another system for them or doing 12 different legislative changes, we can have a statewide impact by just raising the age. And doing it gradually to 19, and then to 20, and then to 21, and trying it and looking at the data all the time responsibly. having a lot of the partners that are here that are really experts on this look at it and continue to look at it, we think that this is a very meaningful impact specifically on young people of color across the Commonwealth. So thank you for considering it. Thank you, Rep. Carvalho, for your leadership on this, and for, as you heard, Chairwoman Spilka and Khan and Senator Cream for leading this important initiative. And thank you for considering it.
Good afternoon. Chairs Brownberger, Chairs Cronin, Committee, thank you again for all your leadership, all your consideration. My name is Greg Croto, I work at UTEC. So we work with young people ages 17 to 25, specifically those young people that already have proven histories of serious gang, serious criminal involvement from the Lowell and Lawrence areas. So we're pleased to be working alongside so many great folks around this issue. I started as a street worker, so I was actually hired by a group of young people. So my background is in street work and outreach, and I can tell you over the X years that we've been doing this, the idea of 18 to 24-year-old is a critical time period in the mid-20s. As Lael mentioned, there's no magic number, but I can tell you beyond the data, we know firsthand that you see young people aging out of it. And there's that window of how we can effectively engage young people is critical. We see it every day. I think one of the key pieces is the employment side, and I'd just like to highlight the economic impact of this bill. So for us at UTEC, we know that in addition to having an ally, that sometimes they may not have it necessarily in other support systems, it's also having that critical piece of employment and training. So we run our own social enterprise. We provide the jobs for them as part of their journey. But we also know at UTEC, as we all know, that the young workforce is a critical asset to our Commonwealth. We also know there's various studies, folks know this better than I, that over the next year and more, there'll be a critical shortage of workers in the Commonwealth, and particularly within the group of young people that we work. In that respect, we see Raise the Age as having the potential for significant opportunity around the economic side of it, and providing young people with the opportunity to not necessarily have that adult record that will, as we all know, will have great negative impact on them. And so we can work with young people to avoid that. That is one of our biggest, we believe one of the biggest assets. I'd also like to highlight the fact that we also see particular cost savings within this type of initiative. So as you know, in the juvenile system, there's a range of community-based services, a really significant array of community-based services that they've been doing for many years. And I'd have to say DYS is well regarded as a leader nationally for their practices and their results. Those community-based services are also less expensive. And so for someone like UTEC and ROCA, the added advantage of working with young people while they're still in the juvenile justice system is they can provide that continuum for the services to also go out to organizations like UTEC and ROCA, so we can pick it up and work with them in hopefully a less costly manner. So we just want to thank you again. I was smart enough to let our young people go on expungement. We stand before you in support of expungement, justice reinvestment, and Raise the Age as well. Thank you again.
Any questions from the members of the panel? Representative Lyons, what's going on over there? Is that feedback? I think that it's some kind of walk outside. It's an elevator line. Okay. Representative Lyons.
Thank you very much for your testimony. And I'd like to really believe that this is a critical age. I have two sons, 22 and 23, going from teenagers through the 18-year-olds to adulthood is no easy task in today's world. The concern I do have is one that I echoed earlier, and I'd just like to know if you have anything on the impact of putting 14 to 17-year-olds together with young people over 18. Is that something that we should do, or is it something that we should be careful of how we do?
So I'm happy to offer an answer to that. Right now in Massachusetts, juvenile justice goes from age 7 to 21. You can, as a youthful offender, you can be confined to Department of Youth Services to 21. So we have an enormous spread as it is. What we have the advantage of in Massachusetts, which doesn't exist in many states, is the Department of Youth Services has a network of facilities across the state, a continuum of care from the most lock secure to community-based. And what they do now, and should be doing as any agency, is they should be dividing that up partly based on need, partly based on maturity and age. And so you don't want a 9-year-old in with a 19-year-old. It would be very important for Department of Youth Services, if this phased in, right, to continue that tradition. I would just say, though, that the research, I did intense research for the governor of Connecticut this year, looking at their proposal to raise the age of 21. And one of the most fascinating elements is that the same thing happened in Massachusetts. When you raise the age from 17 to 18 here, you saw a dramatic decline of the youngest kids in your system. They just didn't show up. And I think what happened, the silver lining is, people thought of more appropriate ways, alternative ways, to serve the youngest kids. That could be child welfare, could be mental health. And I believe there'll be the silver lining that you see in Connecticut and Massachusetts, and also look at the data in Illinois, would occur again. That your system would be able to focus at those older, the most at-risk youth. To really, those are the ones that need the attention in the juvenile justice system. And some of the other systems would need to kick in and help the really young, pre-adolescent kids whose feet don't even touch the ground when they're in the courtroom. Those could be served by many other services.
Thank you very much.
Follow up, Mr. Chairman.
You have a follow-up.
It's also my understanding that there's federal law regarding separation of 18-year-olds.
Yeah, exactly. I also did a huge research study on that. As long as you have, as long as the law is written explicitly that those 18, 19-year-olds will be treated in a juvenile system, even if the juvenile system has, barbed wire, locked doors, etc., they can be put in a system with the younger kids. If you classify them as an adult, then they cannot. So you can't have an adult in, adult court who's sentenced to DYS. It has to be through a juvenile system. There's one other really important advantage in the federal system, is if you're in the juvenile system, you are eligible for Pell Grants. Those are subsidies for higher education, You are not eligible in the adult system. So you're also increasing tremendously the opportunity for 18, 19, 20-year-olds to be getting a higher education, which is what we know, research is another very effective way to reduce recidivism. I don't know if that's helpful.
Yes, one more question.
Very quickly, what was the age? What percentage of students are 18 to 34 still living at home?
I know, it's shocking. I had to look it up. 32% according to, I looked it up again this morning just to make sure I wasn't misreading it or misremembering, the Pew Research Center. And it's, it's indicative, right, that I know I graduated college and went back to home. I expect my kids will probably do the same thing. My 18-year-old is no more independent than my 15-year-old at the moment.
Thank you so much. Any other questions? Hearing none, we will proceed. Thank you for your testimony.
Thank you. Mr. Chair, before I go, thank you on behalf of the panel and the organizations behind it. I want to ask that you report this bill favorably. But also, I'm here on a second minute on behalf, as a clerk of the Massachusetts Legislative Caucus of the Black Latino Caucus, and I have a letter in support of the Juvenile Jail Bill, as known, which is also the Justice Reinvestment Act, H 2308 and S 791, as well as a bill that you, Mr. Chairman, filed, which is the S 777, an act to reduce the criminalization of poverty.
Thank you for your support of those bills.
Thank you.
Greater Boston Legal Services, Brittany Kerr, Katrina Fullen, and Tina Martinez. That's next, and then I've got, after that, I've got another GLS panel, John Roman, Steve Wilson, Paul Score, and Simon. So it's Greater Boston Legal Services?
Yes.
All right.
Katina.
Anybody else? I see two of you. I see four of this.
The others were The others were not able to make it, unfortunately, so it's just going to be me. Good afternoon. My name is Brittany Kerr, and I'm a fellow with the Greater Boston Legal Services Quarry and Reentry Project. I want to thank Senator Brownsberger, Representative Cronin, and the other members of the Joint Committee on the Judiciary for the opportunity to speak to you today. We have also submitted written testimony, or will submit written testimony. Our goal at the Quarry and Reentry Project is to assist individuals in sealing their criminal records so that they can get back on their feet and access housing and employment opportunities. Our experience in sealing quarry leads us to support Senate Bill 777, an act to reduce the criminalization of poverty, Senate Bill 791, an act for justice reinvestment, and House Bill 3084, an act promoting community by further reforming criminal offender record information. These bills highlight a number of provisions that will help individuals re-enter and thrive in their communities. We specifically support shortening the waiting periods to seal convictions. Currently, an individual must wait 5 years to seal a misdemeanor and 10 years to seal a felony conviction. However, these waiting periods keep individuals out of the workforce for way too long. All three bills would support shortening the waiting periods from 5 to 3 years for a misdemeanor and from 10 to 7 years for a felony conviction. Shorter waiting periods are likely to reduce recidivism rates because individuals will be able to return to work rather than returning to criminal activity. We also support removing the crime of resisting arrest from the list of never sealable offenses. This offense can occur under a number of different circumstances that do not necessarily reflect malicious intent of the individual charged. For example, some individuals have received resisting arrested charges if they are acting under the influence of mental illness. Some individuals have been victims of police brutality and have been charged with resisting arrest. The determination of resisting arrest is largely based on the perception of the police officer, and for that reason we believe it's far too subjective to force someone to live with that conviction for the rest of their life. We also support allowing an individual to say, I have no record when applying for housing and occupational licenses. Right now, they're able to say that when they're applying for employment, but it doesn't apply to housing and occupational licenses. This provision would allow individuals that have reformed their lives to be considered on an equal footing with individuals that have never had a quarry. For these reasons, GBLS and the Quarry and Reentry Project in particular support these bills. Today I have with me Katina, and she's trying to move forward with her life, but she's going to show you or tell you a little bit about how some of her charges like resisting arrest or the long waiting periods for felony larceny are impacting her as well. Thank you for your time, and here's Katina.
Great job, thank you.
Thank you, Mr. Chair and Madam Chair and members. Can everyone hear me?
Yes. I can hear. Are you back there?
So I'm a little nervous, so don't mind me. I've never done anything like this before. So I've been working with Greater Boston Legal Services for probably about a year now. They've been assisting me with my record. One of the main reasons why I'm here today to speak is I have a resisting arrest charge from 11 years ago. I was not resisting arrest. I have documented anxieties, and I was explaining to the police that I was a little nervous, and I got charged with resisting arrest. So this is a lifelong record for me. Everywhere I go, this is going to come up. I also have a felony that is not sealable until 2019 for a larceny case where I was charged with receiving stolen property for a little over $250. From my understanding, Massachusetts, we have one of the lowest amounts in what turns a larceny case into a felony. So I'm just asking for the members of the board to look at these two things something that happened in 2009 is 2017. I still can't seal it. I am a nursing assistant by trade. I'm also CPR certified, med certified, but I cannot get a job in any area hospital right now in Massachusetts because of my felony. I am currently enrolled in Bunker Hill Community College, taking prerequisites towards becoming an RN, but I can't apply to any RN program in any of the colleges right now because of my record. So, and I take full responsibility for that. However, I believe it's too long of a waiting period. I feel like I did my time, I served, I was on probation. However, I'm still being punished right now, and I still can't seal to this day. So I'm just asking for the members, Mr., Madam, everyone, to just look at that, and do you think that that is really 10 years? It's a very long waiting period for someone to change. And I do believe people deserve second chances. You're looking at one of them right now. So thank you.
Thank you very much. We really appreciate you were able to tell a story that educates. So thank you for that. Looks like second possibly services panel expert. Just so you know who's on deck next, I got Jose Robles, David Member, and Springfield. Who's the next group? No, you are seated. You're right.
Okay, oh, you're buying.
Just tell them who's on deck. Jose, you're on deck. Please proceed.
Representative Cronin, Senator Brownsburg, and members of the committee. My name is John Bowman. I am an Access to Justice Fellow, a volunteer with the Jobs Not Jails Coalition, and my church, the United Parish in Brookline, is also a strong supporter of criminal justice reform. I'm here today to introduce a panel to speak to several of the criminal records bills that are before you. House 3084, filed by Representative Liz Malia, Senate 777, and House 2359 by Representative Tyler and Senator Brownsberger, and the Justice Reinvestment Act that you've heard from previously by Representative Keefe and Senator Sonia Chang-Diaz, Senate 791, House 2309. Just to begin, the Council of State Governments, from which we've not heard yet today, but we will be soon, underscored in its study of the Massachusetts criminal justice system the key importance of jobs, as well as housing, to move people away from the criminal justice system and into a productive future life. So it's in all of our interest, if we want to reduce recidivism and change the system, to relook at how our criminal records acts influence that. So the first person to speak will be Ellis C.
Good afternoon, Chairman. My name is Ellis Ford. This is reading HB 3084, HB 2308.
So I was going to ask you to try to speak up a little louder. Make sure everybody hears you.
Okay. To the chairman, to the chair, and the members of the joint committee, I ask you to pass the above listed bill, which would shorten the waiting period for sealing criminal records and permit me to seal my entire criminal record. I have shortened my Corey report by going to court to seal dismissed cases. Judges were sympathetic and sealed my case. Sympathize with me and seal my case. However, my life is on hold because of the long waiting period to seal my past convictions. I am homeless and chronically unemployed. Because of my Corey, I can't seal my Corey until 2019 because of a case I picked up in 2007, which include loss of charges that are felony, where I was found guilty in March 2009. Corey is something that keeps you from being able to find work and live a full life. I have a record that goes back a long time, and my record has held me back many times from getting legitimate jobs. I am 63 years old. I pose no threat to anyone. Please let me live out my rest of my life in a better way and to climb out of poverty and homelessness. Now, I read that from the paper, but what I want to say from my heart is I had to earn those 7 years of not being involved in the legal system. I had owned up to my past mistakes, and I have worked with other homeless people, shelters, which I am, and addiction over at what they call 3 Mile Island, over there in Northampton. Okay, every day I have to go over there and do NA groups, and etc. A lot of times I go to CAB with a detox to tell my life, my past experience. And a lot of times people are saying, what the heck, okay? The Corey is always holding them up. Even if they have 2, 3 years recovery, 4 years, they give in. They give in. I refuse to give in, okay? I'm staying the course. I have records here where I go to court, each and every court I have to go through, to apologize to the Commonwealth and to tell them that I am truly trying, I have changed my life, still my record. And so I ask you guys to lower the threshold probably to 7 years. That would really be helpful to me. I can go back and tell my peers that keep the faith and keep working. Life is not over.
Thank you so much for that, sir. Thank you for that very personal thing you really gets across. Stay with us a second. Let Cassandra testify and maybe a couple of questions.
Hello, everybody. Nice to see you, and it's good to be here. I'm Cassandra Ben-Sahi. I'm a community activist, and I'm also here on those bills, reduction of the criminal record ceiling time. As a woman of color, I have worked really hard to overcome and resist some of the constrictive barriers that having a criminal record have presented in my life. I'm also a member of the post-incarceration community. It has become evident to me that 6 months in a state prison for women due to my drug addiction, that is 10 years behind me, has not been enough, and I've worked really hard in the community to make a lot of changes. I have helped hundreds of people seal their records, but I realized that a reform in this criminal record process of sealing time being decreased even to 7 years, with the statistics saying that 1% of people after 7 years will reoffend again. Today, I still have to explain myself when looking for housing and looking for jobs. I tell people to be encouraged because we are working hard to make a difference in the way the system holds people back. You can work really hard today to turn your life around and then find yourself in a position that you have to explain that all over again, even after 8 or 9 years in one job. Today is a day that I realize more than ever, we really need to look at how people are being held back. If you're given that opportunity to get that job of your dreams or be better in our community, it's only going to make things better for everybody. People want to contribute, but they're not allowed to. So I just imagine living in a community with no sense of belonging when you go and reach out to do something to help. It's just not good, you know, we need to work on this. And I implore you to look into it. I know there's a lot of support up there, and it's just good to be a voice for this cause. Thank you.
Thank you for your advocacy for what we're doing. Other questions? No? Thank you so much for staying with us and for the testimony.
Thank you. If I may, Mr. Chairman, there was a third panelist. I could read her statement. She could not get released from work, and I also have it to submit to the committee and distribute it.
How about if you just submit it?
I will do that. Thank you.
Appreciate that. Jose Lopez.
He has to leave, so I'm part of the group. I said he had to leave. I'm part of the group. Yes. Neighbor, neighbor.
Oh, you want to see, okay. Thank you.
Thank you.
Please go ahead.
My name is Jacqueline Velez. I'm an organizer for Neighbor to Neighbor, an organization that works to make conditions better for the most marginalized, unfairly targeted population on a variety of issues, such as immigration, criminal justice reform, climate justice, and much more, by mobilizing the very population directly impacted by the issues I just referenced. This population is Black and brown people, my people. I'm here in support of the Justice Reinvestment Act, House number 2308 and Senate 791. Having a criminal background and serving time creates many barriers upon release for people when they return to their communities. Most folks coming home, men and women, are dealing with reunifying their families, fighting to get their children back, securing housing, employment, adhering to all the conditions under which they may have been released under to parole or probation departments of the state. They're also trying to continue their education, adjusting to life on the outside after being traumatized and dehumanized. If any individual comes home from prison or jail and is making attempts at piecing the parts of their lives together, we should do everything in our power to support that effort. I do believe we all as a society want the same outcomes. That outcome to be that everyone returning home from prison or jail become fully contributing citizens to society and their local economies, reducing recidivism and saving state funds. Imposing high probation, parole, and court fees, sending people back to prison for not being able to pay those fees when it costs taxpayers thousands of dollars to incarcerate individuals in order to charge them $29 a day is not the way to reach the mutual outcome both sides of this argument want. To continue to list dismissed cases before arraignment and certain juvenile cases on their criminal background record, allowing sealing record time to be 5 and 10 years for misdemeanors and felonies respectively is not supporting that effort. To continue to allow people's records to be on the FBI's database, not to repeal mandatory minimums for drug offenses, and not making judges the neutral arbiters in a court of law is also not supporting that effort. To support those efforts would mean giving people a second chance, and in some cases, third and fourth chances. It would mean to invest in people before prisons. To think of people in prison and jails and those that come home simply as people. Not as felons, ex-felons, convicts, ex-convicts, inmates, or ex-inmates. People are people, not to be thought of as disposable. It would mean putting people before prisons, investing in jobs and not jails. If we want people to come home and be productive members of society, we need to do better. We deserve better. If it weren't for organizations such as Neighbor to Neighbor that invest in individuals such as myself, a Latina mother coming from a low-income community, and a formerly incarcerated woman, I would not be able to stand before you now to testify. On behalf of my people, I urge you to remove some of those barriers by supporting the Justice Reinvestment Act. Support those efforts. We cannot wait any longer. Let's get it right now. Thank you.
Thank you very much.
That's it, sir.
Are you speaking together?
Yes.
Okay, thank you very much for your statement. Other questions from members of the panel?
No, I'm okay.
Thank you.
Thank you. Thank you.
Amy Fernandez and Robert Morrison. Reverend Dave Capozzi.
He had to leave in his testimony. He's from Rockford.
Okay. Sheriff Casey, that's the Scranton County Community Organization, right? Thank you. Thank you for coming forward. And so you know who's next after you is going to be Meredith Conant and Marianne Frangulis and more. Is that right?
Good afternoon, everyone. So I stand here today to talk to you about the Justice Reinvestment Act, along with Senate S-791. Now, I'm going to give this story to you as a testimony from my heart, from my own experience, a story from the one that is left behind. Because the system of mass incarceration does not only affect the person that is in the prison, but it also affects the one that is left behind. When I was about 6 months pregnant, my son's father went into prison. Now imagine being a mom, planning for a child, getting ready for a child, and at 6 months pregnant, you find out that your son's father is in prison, and not only is he in prison, he is facing 30 years. Now luckily, due to his family being able to take out a loan on their home and all of these horrible things that they had to do to save him, he only did a year. He was able to get a lawyer to represent him. But when he came home, he was labeled and he could not find work. It was a challenge. Thank God he had a supportive family that was able to support him, that was able to look into what the community had to offer to save him. And my mother and I were able to find the Boston Carpenters Apprentice Program, which you are able to apply as many times as you want to, and they don't look at your previous experience with incarceration. He was able to apply twice. On the second time, he made it in, and his whole entire life changed. He had on-the-job training, and he had work. So he was able to change his life. Now, he did well, but unfortunately, he ended up injuring himself and had to leave. But he had an opportunity to save his life. And what I stand here to tell you today is that not many people have those chances. Not many people have protective factors. Not many people have organizations to plug into or families to save them. And they are crying out to you. They are crying out to you saying, jobs, not jails. Jobs, not jails. Do you see me? They are crying out to you. Generations are falling into these traps and going over and over again and falling, and they are crying out to you to do something. So I stand here today and I urge all of you to change this system, to find ways to help people find work. They need jobs. They don't need jails. I have a son, and I don't want him to fall into this system. We know right now that 1 out of every 3 black and brown boys are going to experience the system of incarceration, and appointed leaders here in this state say that our criminal justice system is okay? Thank you.
Thank you very much.
Sorry, let me sit down. You have questions?
Good, thank you so much.
Thank you.
Marianne and Frangulis. And her panel coming up after that is Christine Topp. On deck, Christine Topp. And after that, the Mass Bar Association panel.
Hello, Senator Brownsberger, Representative Cronin. Thank you very much, and thank you to the whole committee for hearing us today. I am Marianne Frangulis. I am a woman in long-term recovery, which means for me, I have not had a drink or a drug in over 30 years, and it gives me the opportunity to stand up for the people that we believe in. More Massachusetts Organization for Addiction Recovery is a statewide organization of people in recovery, families and friends who want to educate the public about the value of living in recovery. Proud to be the executive director. We know that 80% of the people who are in our prison systems are there for some reason related to alcohol and other drug addiction. Thus, we support the whole Act for Justice Reinvestment, as well as the other bills that support diversion, as well as other bills that support treatment instead of incarceration. And We truly, truly believe that we know that Massachusetts citizens are paying an enormous bill for incarceration, both in financial terms for the human nature of the devastated lives. In 2014, according to a statistic that we read, that it cost an average of $53,040.87 to keep one person incarcerated in Massachusetts prisons. That would cost more than the tuition to go to Harvard University, over 10 times the cost of supervised probation, parole, or community mental health. It is about double the cost of a full year of residential addiction treatment. That spending is especially concerning when considering that 2/3 of the people leaving county jails and half of the people in DOC go back to prison. People need an opportunity. This is about investment, and we want to support our people. And speaking of an investment, before I go any further, I'd like to introduce you to Meredith. She is a person that can demonstrate that investing in someone's life can help them turn it around in a very positive way. Meredith.
Thank you, Mary Ann. And thank you, Senators William Brownsberger and Claire Cronin. Thank you for having us here today. My name is Meredith Cuniff, and I am a woman in recovery. I am glad to participate in the hearing with Massachusetts Organization for Addiction Recovery. I strongly believe in the MORE mission to organize recovery individuals, families, and friends into a collective voice to educate the public about the value of recovery and addictions. I am a proud member of the Jobs Not Jails Coalition. Thus, I am here today to share my story and hope that it will help move these legislative proposals into law, most notably diversion to treatment. I grew up in an Irish Catholic two-parent home. I went to college. I studied nursing. I received my license in 1997. Shortly after that, I had a child, who I then and still now say is the air I breathe. When he was 9 months old, I was diagnosed with relapsing remitting multiple sclerosis. I was sick and hospitalized with this condition years ago and had unusual and piercing pain in my arms and legs. My doctor prescribed me Vicodin, and the moment I took it, something happened to me. Something changed. I began needing more and sought out stronger medicine, and eventually was on fentanyl patches, Percocet, and Klonopin. I was abusing all of this medication, and when my doctor caught on, he stopped me suddenly. I remember laying as feeling as if I was going to die, vomiting, heaving, bone-crushing pain, and there were 2 lines placed on a table, and I was told if I sniffed them, I would feel better. I remember not caring what I was sniffing because I was so sick I thought I was going to die. When I was told I had sniffed heroin, I was so furious. That was the drug I went out of my way not to use. This drug is incredibly powerful, and that within 24 hours I was shooting this drug, and within 6 weeks I had robbed banks to support my habit of getting arrested. I was a mother, a nurse, an active member of the community just prior to all of this. The last time I was arrested, I was sent to MCI Framingham on a Section 35. There I laid in a tiny cell locked in for 23 hours a day for 3.5 weeks. I was never so sick in my life. I was hallucinating, vomiting, and gratefully reached a state of desperation, but I never wanted to feel that way. After the initial 3.5 weeks, I was sent to general population. There I became willing to do absolutely anything to stay sober and to have a good life, but I was in jail and had a hefty sentence over my head. I was alone, desperate, and scared. I had lost everything, my condo, my car, my son, and my soul to this drug. I knew I needed treatment. My father thankfully hired a wonderful attorney, and with his help, the judge gave me a second chance at life and sentenced me to long-term treatment and 5 years probation. I went to a therapeutic community in Hopkinton where I learned how to live right again. I learned about this disorder, I learned what to do to stay in recovery, and I also learned how to live right by simple things like making my bed, becoming accountable for my behaviors, and attending recovery support meetings 6 groups a day, counseling 3 to 4 times a week. I stayed at this facility for 6 months and came home a brand new person. I was able to continue my vocation in nursing, something I fought very hard for, and I'm proud that I can do today. I've been employed as a nurse specializing in addiction since I got home from treatment. Also something I'm very grateful for. I am able to give treatment to the women I care for today that I was unable to have when I was incarcerated. I will have, God willing, 5 years of continuous recovery on August 29th. Had I not had the opportunity to go to long-term treatment, I do not believe I would be here, able to share this success story as a mother, nurse, daughter, and friend. Treatment gave me more than mental, physical, and spiritual wellness. It gave me hope. Without hope, there is no chance for a full recovery of any disease. I continue to treat my disease a day at a time, and I hope for tomorrow. Please strongly consider giving these legislative proposals the opportunity to become the law, to support alternatives to mandatory minimums with long-term treatment and recovery support options. Thank you.
The emotional testimony, we understand we want to support people. Thank you for coming on here. We're the first to start. Thank you. I understand people want to support you emotionally because it's a lot to come out of a person's story like that. So thank you for doing that. Are there other questions from members of the panel? Thank you so much for speaking from the heart of your own story. We appreciate it. Now, is Steve off here?
I have with me Norma Wassel, also from the organization. Thank you so much for the time today, Chairman and Chairwoman and members of the committee. My name is Christine Poff, and I'm the Political Director at the National Association of Social Workers in Massachusetts. We have 7,000 members across the state in every district. And we have a very active committee that works on criminal justice issues, that cares deeply about a whole range of bills that are being presented today. I'm here specifically to testify for the Justice Reinvestment Act that we have prioritized to work to get passed. And we did so because we feel like there are so many pieces of it that would make a huge difference for people in jail and who've just been released. We support the mandatory minimums for ending mandatory minimums for drug crimes. Social workers know well that addiction is a disease, and we must stop treating it as a crime. And when funds are diverted to increase treatment instead of paying for incarceration and court costs, crime and addiction go way down. So that's our first concern is ending mandatory minimums for drug crimes. We want to decriminalize poverty by eliminating probation, parole, and court fees. We know that when that happens, incarceration goes down and the state reaps savings. So we feel like many of these bills will save money and help us support some of the programs that are in the Justice Reinvestment Act and some of the other bills being considered. We want very much to increase funding for job placement and education programs in jail and outside of, and for when people are released. Many of our social workers, all this comes from their stories. They work in jails, they work in community settings, they work with people with addiction who get involved in criminal issues to support their habit, and they work with people with deep trauma who, and the addiction comes from that trauma, and so do many of the things that land them in jails. So on behalf of social workers, I hope very much that you will pass the Justice Reinvestment Act out of committee, which is House 2308 and Senate 791.
Hi, my name is Norma Wassel. I'm also a member of the NASW Criminal Justice Working Group. I'm also the founder of the Massachusetts Bail Fund and currently still chair of their steering committee. I'm also a professional that works in the criminal justice system throughout the state, so I speak from the context of that kind of involvement. We're echoing the support of 777, of the Act to Decriminalize Poverty, and also Senate Bill 745, an act to restricting the fine on sentencing. These are two bills that severely impact people's lives, even though they're small amounts of money. Many of our clients cannot pay that small amount. They might lose their kids, lose their housing, even going to jail for a weekend has a significant impact. The other bill that is very positive, but also there's some concerns about, is Senate Bill 834, the Act for Reform Pretrial Process. We have some concerns about elements of that bill, but support others, and I just wanted to give a small history background in the Massachusetts Bail Fund to encourage you, to let you know that changes that you can make in these state statutes based on these bills are really, really important. The Mass Bail Fund has bailed out since its inception in 2011, started bailing in 2013, about 585 people. Our forfeiture has been 6 people. We only post bail for people under $500. Average bail is around $365. We don't do any risk assessment to appear. So this is an indication that provisions in that bill could actually work, as well as other recommendations for change in the criminal justice system.
What were those numbers again?
We post in 5 counties with 2 more to come. We posted 585 cases, all under 500, 6 forfeitures, which means we've lost the money, and we also, our average is about $65 per case, but they range from $50 to $500. This is an indication that these people are still in jail. They haven't been released on their own recognizance. They've been in jail for either not being able to afford their bail, or the judge has not seen them to meet the criteria currently in our statute. Our history and our record of posting those bails for individuals who don't meet that criteria still shows that that has been possible despite what our current system says, which indicates that a large number of people, including the Mass Trial Court, show that there's a percentage of people still in jail simply because they cannot afford their bail. And those are disproportionately African Americans and Latinos who end up with higher bail and unfortunately lower ability to pay. We've been cited in the Mass Bar Association's Criminal Justice Working Group as our track record is an indication that this elimination of bail or reduction of the amount could in fact shows that you can release people either with or without assessment. We have real practical experience in showing this. So I hope you'll take this as an example of reforms that can be made, what we are practically doing as social workers all over the state, and you'll take this opportunity to actually end the dual system of Massachusetts criminal justice system, where there's one system for people who have the means and one system for people who have no means or are the poor and are in jail for lack of money.
Thank you very much.
Okay.
Questions from members of the council? Thank you so much for working.
Okay.
Thank you so much.
We have the Mass Bar Association on deck, Timothy Rhodes, GBIO. So Mass Bar Association now on deck, Timothy Rhodes.
Good afternoon. I guess I'll go first. My name is Peter Ellikin, and I'm going to address the MBA's support of Senate Bill 755 and Senate Bill 777, an act to reduce the criminalization of poverty. And let me preface this by saying that sometimes criminal defense attorneys like myself get so fixated on simply keeping people out of jail right at the time of sentencing that we'll do anything. We'll bargain to keep them out of jail and we'll pay any fees and fines and community service and heap it on, just keep them out of jail at the moment. And we forget and we overlook, I'll say this, that we're often just kicking the problem down the road, that we overlook that our low-income defendants wind up incarcerated due to poverty, unable to pay the litany of fees and fines. And the result is something out of Dickens. It's evocative of the old debtors' prisons where people are sitting in jail not for really committing any offense, but really just for the reality of being poor. And in recent years, it's gotten so much worse. It's really reaching a crescendo. Until the 1980s, there weren't even probation fees. And in the last few years, they just keep heaping on an extraordinary number of fees and fines, and some people are drowning under them. That you pay a few $100s a month for GPS. There's license reinstatement fees, required program fees. You have to pay for court-appointed counsel now when they used to be free. Also, the amount of probation, all these fees just keep getting raised. Probation fees have been raised, and it doesn't always logically correspond to the seriousness of the offense. For example, drunk driving, you're going to have a lot of an OUI, first offender OUI, drunk driver is going to have an awful lot of more built-in fees and fines than somebody who does attempted murder, a sex offense, you shoot somebody. The issue has come to the forefront. I understand this, this bill, particularly 777, is really just part of a nationwide trend. In March of 2016, the Federal Justice Department came up with a number of recommendations concerning fees and fines. The Massachusetts Judiciary, the Chief Justice of the Trial Court, called a working group, and it seems they've kind of were in lockstep with the Justice Department. And the bill here that was introduced by you, Senator Brownsberger, is really in step with kind of the rest of on the cusp of this national trend, not just here. I won't go through the laundry list, but I just wanted to briefly say that we really want to just give judges discretion to waive fees and fines, and nowadays some of them are just inflexible. And when there are fines, the court should be able to give somebody a hearing to decide whether it's willful or whether it's really just they don't have the ability to pay. And we should eliminate the post-release probation fees. I think I don't need to go on and go through the whole list of the bills, but just the bottom line is we've got to go out of our way, not just because this isn't just to be kind or to coddle offenders. It's really, this really lowers the recidivism rate. It enhances public safety when people aren't so wrapped up in their families and doing these fees and fines that they don't work on their staying out of trouble and doing the kinds of things they need prior to their offense. Thank you.
Good afternoon. My name is Charlene Verma, and I am here on behalf of the Massachusetts Bar Association, but I also work as a full-time staff attorney for the Committee for Public Counsel Services. So I'm one of those lawyers that's wasting all the money right now, as another person said that. That aside, I would like to... Okay?
It's a difficult subject.
It is, and I disagree with that past person. I think you provide very good work, even for people who are not facing incarceration. I'd first like to talk about the bail statute, or the bail bills that were proposed this year. The Massachusetts Bar Association had a working group that the three of us were a part of. It was a criminal justice reform working group, and we had a report that was endorsed by the House of Delegates. The Massachusetts Bar Association recognizes that pretrial incarceration of persons awaiting trial has severe collateral consequences and can cause real harm to individuals and families, such as loss of employment, economic hardship, disruption of education and training, and can exacerbate existing mental health and medical issues. It's important to remember that in Massachusetts, bail statutes include a presumption of personal recognizance, and I think that's important to remember. The least restrictive means are rarely employed, and cash bail is routinely used in place of social services, and this is something I encounter as a staff attorney. What is more troubling is that recent studies throughout the country have determined that detaining low to moderate risk persons pre-trial, even for periods as short as 72 hours, can lead to increased rates of recidivism. The Massachusetts Bar Association also recognizes that requiring a person to post money does not ensure appearance in court. Things like robocalls or pretrial services, which is outlined in the report that we actually have copies for you to see, are actually quite effective in people coming to court. Basically, that is, we would like to support Bill 802, 827, and 834. I would like to speak first about Bill 827. It is an act relative to review of bail for inability to pay, and I think this is one of the most important bills that was brought before on the issue of bail reform. Presently, a person held on a cash bail is entitled to only one bail review in Superior Court. This bill actually provides two other chances for somebody to have a bail review, and I think what is very important is that first bail review is entitled 72 hours if a person is still being held on the cash bail. I think that is very important. Bill 834, we have mostly support, but I would say that the committee has some concerns about the risk assessment tools that are going to be employed. If this bill were to pass, they tend to be very cookie cutter and don't incorporate subjective or qualitative assessment tools in a meaningful way.
Thank you for your time and testimony.
Good afternoon. My name is Pauline Curie, and I'm the Vice Chair of the Criminal Law Section. My name is Pauline Curie, and I'm Vice Chair of the Criminal Law Section of the Mass Bar Association. But my day job is at Greater Boston Legal Services, helping people seal criminal records. The Mass Bar Association is here to support Senate Bill 791, 777, as well as House Bill 304, which have to do with CORI consequences and collateral consequences of criminal records. Since my time is limited, I'll be brief. First off, it's really important to reduce the waiting periods. CORI reform from 2010 just didn't go far enough. We need to reduce the waiting periods from 10 and 5 to 3 and 7, which is actually consistent with recidivism literature, which shows that most people after 7 years have the same likelihood of committing a crime as somebody who has no criminal record. And most recidivism happens within 18 months to 2 or 3 years, so those time periods would be appropriate. The other thing that's important to recognize, as you heard from people testifying, is young people always get in trouble, often get in trouble at a young age. You have shoplifting cases. Our felony larceny amount is also really low. It's only $250. So in my work, I see people, very young. They're 19 years old, and they have a felony case on their record, which they can't get them out from under for another 10 years. And nobody can afford to be unemployed for 10 years. And the reality is, even with a dismissed case, you're going to have a real problem getting a job. Another item which is important to the MBA is the ability to seal a resisting arrest offense. I see a lot of people in my practice who have opiate addictions, or they have other mental health issues, or sadly enough, they were treated insensitively by the police, or even were brutalized by the police and pick up these kinds of charges. It's really not fair to give somebody a lifetime criminal record. And then there were a few things, the devil is always in the details with CORI and how the law is implemented, but there are some strange things in the CORI system. One big thing is that juveniles who have youthful offender cases, and if they are either have probation beyond 21 or they're sent to jail for some period of time. I have a client currently who had to work today, so she couldn't come to the hearing, but when she was 14, she was arrested. She had a juvenile case. She served some time at a facility, was in DYS custody until 21. Now she's 22. She wants to further her career, and her juvenile case is still appearing on her record. So to wrap it up, I would suggest that in particular you look at House Bill 3084, which includes a lot of wonderful CORI fixes, which would fill in a lot of gaps in the current law. And I'm going to submit copies of the MBA resolutions on criminal justice reform, fees, fines, and bail.
Thank you so much for all of you. Any questions from members of the panel? I'll look forward to it. So I enjoyed that document, the bills that you are, the MBA that's coming together around.
Yes. Not in this document. We'll actually be submitting supplemental testimony with a list of the bills.
All right,
Thank you.
Timothy Rose, did you get out?
So he had to head out, but he was going to read one of our member testimonies, which I will do instead.
Okay, we'll do the same testimony. All right.
Thank you, Representative Cronin. Thank you, Senator Brownsberger, and members of the Judiciary Committee. I'm submitting a testimony on behalf of one of our members. She's a member of Hillel B'nai Torah, which is one of our 45-plus member institutions with the GBIO, in support of Senate Bill 755, House Bill 2359. And I read, my son was released from incarceration at Boston pre-release in August 2017. He was one of the lucky returning citizens who left prison with a job and a place to live. In his case, with his girlfriend. But his job was only part-time and at then minimum wage of $10 per hour. He was on parole and probation concurrently. His fee for parole was $85 per month. For probation, it was $35 per month. He was also fortunate that his probation officer was willing to waive his probation fee, but that still left him with a monthly payment and that totaled more than a day's take-home pay, about 10% of his total monthly take-home income. That might not sound too onerous if you have disposable income. It's a small fortune when you're averaging $240 per week in income and have to pay for transportation to work, try to help with the rent, groceries, and daycare costs, and must literally gear up to civilian life after 3 years of incarceration. So what made it possible for him to pay? His girlfriend subsidized his fee by paying the lion's share for their living expenses and driving him to work. His retired parents subsidized it by making monthly contributions to his bank account. We're not the ones on parole and probation. Fees for returning citizens are dropped in the bucket of the state's budget. They have a much bigger impact on the people who pay, especially those who, like my son and his girlfriend, struggle to get by. At best, they have dubious effect as deterrents to recidivism, and for some people, the ones who don't have a job or place to live, or someone else to subsidize their costs, or the ones who never learned to budget because that didn't come up in prison. They can be the cause of recidivism. Estimates vary, but a year incarceration costs Massachusetts taxpayers somewhere between $47,000 and $52,000. Is there something wrong with our math? From Judith living in Newton, Massachusetts.
Thank you for that statement. I'm going to take a break.
Dirk Stryker.
Thank you very much. I'm here as representative of EMIT, UU Mass Action. It's the working group on criminal justice reform of UU Mass Action, and I am supported by some of my colleagues who have come to give me moral support at least. I'm here particularly to speak in support of the Senate Bill 791, an act for justice reinvestment, through the establishment of a Neighborhood Safety and Opportunity Trust Fund, which I think is extremely important. The Judiciary Committee is certainly considering a long list of bills in the area of criminal justice reform. And the list is long because the need is very great. And many of these bills are designed to reduce the rate of incarceration in Massachusetts, but with all of the waste and inequities and costs this entails. But reducing incarceration by itself is not sufficient, as we know. We need to have accompanying measures, and so it's particularly the focus on the financing of the accompanying measures and making that community-based in a way that helps to integrate ex-offenders back into their local communities is, I think, very important. Now, we know that the various measures that are being proposed will, some of them more effective than others, but certainly in broader magnitude, are sufficient to lower the costs of the criminal justice system. That's part of the objective of the whole process we're going through. But the question is, how do we, in fact, enable the activities that are taking place to benefit from the reduction in costs? And so we have the proposal here in this particular bill. Now, Massachusetts would be well advised to learn from the experience of California, which in November of 2014 passed a referendum known as Proposition 47, the Safe Neighborhood and Schools Act. And this act converted many nonviolent offenses, such as drug and property offenses, from felonies to misdemeanors. It also required that the resulting savings from this measure be spent on mental health, drug abuse treatment, and other programs designed to keep ex-offenders out of prison. The act went into effect immediately, that is, the following year in 2015. As substantial numbers of people who were incarcerated at the time petitioned for resentencing and were released. In addition, others avoided incarceration altogether under the terms of the new act. What did not happen immediately was the allocation of savings to programs to assist those who were being released or putting on probation. Too many were left adrift with little support and often found themselves back in prison. And only now, 3 years later, is the fund actually being established, and proposals are being submitted to carry out the terms. Now, this particular bill that we have before us, Bill 791, is very similar to this, and I would argue that it's extremely important that this fund, the mechanisms of this fund and of the replenishment of this fund through the savings that are achieved through various reforms being proposed, be put in place, and not be put in place tomorrow when it's going to be too late. It takes time for these kinds of funds. But I think that what's very important, and this has already been outlined, I won't talk much about the goals of the fund itself, but it's very important because it's neighborhood-based. It has representatives who come from the local community and who have, in many cases, experienced incarceration. And furthermore, what is really very remarkable is that it is well spelled out. The management program framework is well spelled out in the bill and serves as an excellent base for building it in this particular field. Thank you very much.
Just a quick addition, Susan Tordella. I would like to ask people in the audience to stand up who are here because you are personally, morally outraged at our justice and correction systems. So the committee sees this. And a lot of us are here because we're volunteers. We're not paid staff. Thank you. The other thing I want to point out, I have to go catch a train, is that, did you notice that the white woman who's the nurse, the woman in recovery, she got treatment. Right. And the woman who spoke before her, the black woman who wants to be a nurse's aide, has a Corey. She did not get treatment. Those two examples just speak miles about how our system works in this state, and we ask you to do your best to change it this session. Thank you for all the work you do.
Thank you. Thank you very much. Reverend Jonathan C. Keller. I don't know who you are.
I watched a shotgun back here. Yeah. I chair the Actual Justice Task Team in the Massachusetts Conference of the United Church of Christ. Mary Valerio here is also a member, and I'm speaking in support of the Justice and Reinvestment Act. Many times, the Massachusetts Conference of the United Church of Christ has expressed its interest in a fair and effective criminal justice system and a humane system. And we go back to 1981 for a resolution opposing presumptive sentencing, to last year's resolution advocating the end of mass incarceration, and very much in between and even before that. And sometimes we have tried to prevent bills that have caused more pain, more problems, but it's great today to be able to support a bill that is going to help us. The omnibus bill would attempt to reduce incarceration levels and at the same time provide money to support job creation for those who would be incarcerated or who have been incarcerated. Mandatory minimums. There's been already some discussion about that here, and I think the shaky grounds on which such mandatory minimums legally are placed. If the prosecutor chooses the offense, if the person is found guilty of that offense, the judge is taken out of the picture in terms of reducing anything that he or she feels is appropriate. I don't think that's right. And of course, if we reduce that, whether it's for drug offenses or life without parole, get rid of mandatory minimums, we'd have a fairer system, and I think a more constitutional system. Probation fees, we've heard much talk about that. I don't want to continue, but that's also part of Justice Reinvestment Act, and if we didn't have those fees, people struggling to try to make it somehow in this world would have less of a problem. Another one is the raising the minimum the minimum felony charge for like shoplifting from $250 to $1,500. It sounds like a terrible proposal. It's very modest because that $250 was established back in the 1940s, and it's been calculated that would now be worth over $3,000, so $1,500 is pretty moderate. I won't say more about Corey, much has been said, but I want to say that I work myself in the criminal justice system. I work with many fine people, and I think many may be afraid of what this act will involve in terms of their own employment. But I got to say that there's a lot of turnover, there's a lot of retirements, and I really think that personal pain should not be a problem as jobs are eliminated, because I think there's going to be plenty of jobs, people resigning and retiring from those jobs.
Thank you for your testimony.
Well, hi, my name is Mary Valerio, and as John mentioned, I am a participant in the Actual Justice Task Team. And one of our missions is to work to help innocent people who are incarcerated. And I have a personal interest in this because I have a family member who is incarcerated, who was wrongfully convicted. This family member was deported by the federal government 20 years ago and has now all of a sudden been dragged back into the country by the Worcester District Attorney's Office. So as we're trying to work through this case, I have seen a lot of the different things that go on in the criminal justice system. And I think that a lot of reforms mentioned today would really help people and would really make things better for those who are in prison and give them a better chance when they get out. And also, I think that there is a perception that everyone in prison is a really violent, terrible person. And I would like to say from my own experience visiting at the prisons, that is not necessarily the case. And that every person is a human being, and that everyone's family truly cares to try to help that person. So I hope that when you're voting on legislation, you'll remember that these are real human beings with families who care about them, and that your decisions need to be really courageous.
Thank you for your testimony from the heart. We appreciate that. Questions, members of the panel? Thank you so much for being with us today and for the work you do. Let's see. So I asked Representative Conley to come back later. She's come back later. I'm going to pull her in and get her testimony, although it is not on the subject of the royal.
Thank you very much, Chairman Brownsberger and Chairwoman Cronin, and to the rest of the committee. Thank you for taking me out of turn. I was here earlier. It was a large crowd, and I had to testify at another hearing and a few other things, so I'm back. And I'm not going to take much time because I know most of the bills that I'm supporting have probably already been heard, and you haven't heard a lot of detail, but I just wanted to say that...
We're still on the first category, actually.
Well, I'm just, so I just want to identify myself as Representative Kay Kahn of Newton. I'm the House Chair of the Joint Committee on Children, Families, and Persons with Disabilities. I'm a member of the Criminal Justice Commission and co-chair with Representative Barber of the Caucus of Women Legislators Task Force on Justice-Involved Women. So sort of been around for a while doing trying to do a lot of things in the criminal justice area. But before I talk about the 4 bills that I have before me, that I would like to offer support on, I just wanted to mention House 874. I know that this is on the cost of appeals, and I know that that DA Ryan was here to testify on that, so I'm just going to put in a word of support for that. And the 4 bills that I really wanted to just mention are House 875, an act relative to best practices in the juvenile court, House 2309, an act relative to sealing of juvenile records, House 3078, an act to promote better public safety and better outcomes for young adults. That's the Raise the Age legislation. House 3079, an act to promote transparency, best practices, and better outcomes for children and communities. And that's a juvenile justice omnibus bill that actually has 6 points. And I'm not going to go into all of those 6 points, but so I really just wanted to be here to basically just reiterate what probably everybody else has said, which is that we know that things have changed, that a lot of research has been done, we know that the brains continue to mature into young adulthood, and we know that youth often lack maturity, impulse control, foresight, and the ability to appreciate the consequences of their action. But they can grow up to be responsible adults, and I think we need to really consider, we raised the age to 18, for example, a couple of sessions ago. I think to go to the age of 21 makes a lot of sense. There's a lot of work being done around juvenile justice, taking a look at the 18 to 24-year-olds, and that we know that there's a lot of crime that occurs in this age group, and we would rather see them have another chance and to get the support and services that would really make the difference and perhaps move them into a more responsible kind of behavior. I think it's about public safety. It's about really using our dollars to help promote education and training and so forth. So my time is up, but I just wanted to be here to say that I'm very much in favor of doing what we can for the youth in the state.
Thank you for your support. Thank you for your continuing leadership on these issues. So much appreciated. All right, thank you very much. I'm told that there is a panel, there's a presentation happening at 5 p.m. today at the Boston Bar Association on civil forfeiture, that there are several members of the panel who are here who seek to be part of this hearing before they have to go to the other hearing, so I'm going to ask them to come forward at this time.
Good afternoon, Mr. Chairman, Madam Chairwoman. I'm Rasan Hall with the ACLU of Massachusetts. With me are John Malcolm of the Heritage Foundation, Robert Johnson of the Institute for Justice, and Russ Caswell, a citizen of Tewksbury, Massachusetts, correct? Right. Correct. Okay, and we are here to testify in support of S820 and H2316 relative to civil asset forfeiture, or the bill is titled an act relative to criminal forfeiture. The ACLU is a firm believer that transparency, accountability, and due process are fundamental elements of a just and democratic society, particularly when those elements are embraced by law enforcement. It gives another level of credibility to the notion and the idea of the rule of law. Currently, Massachusetts civil asset forfeiture laws are not consistent with those values and principles. The Institute for Justice recently issued a report entitled Policing for Profit, and we earned the grade of F based on our current laws around civil asset forfeiture. It's very important for us to recognize that there should be different standards that exist for the state, particularly law enforcement, to not only seize but forfeit people's property, whether it be cash, real property, or vehicles. And so the panelists will talk more broadly about some of the national context as it relates to what's happening in Massachusetts, the particular findings of what is happening here in Massachusetts, and the personal experience. One thing that I would like to lift up as it relates to transparency, currently the Massachusetts District Attorneys Association is required to file a report every year consistent with their budget line item to detail what they do with the forfeiture funds that they receive every year. That is not readily available. You go to the House Clerk or the Senate Clerk's office to look for that, and they have to search, and they haven't found all of the reports. When you go to the Massachusetts District Attorneys Association, if you can find the location, they will provide it. but it is not a very detailed report, and it does not account for the funds that are recovered by the Attorney General's office, and it does not provide a breakdown for what police departments do with those funds. And in regards to accountability, to be accountable to the public, we're talking about an opioid crisis, and some of the district attorneys testified earlier here to the need to put funding into the opioid crisis. Of the $13 million that they seized over the last 3 years, only 8% of that went to funding for drug rehabilitation or drug education programs. They spend approximately 65% of what the total deposits are to collect more forfeiture funds. So I'll stop here and turn it over to the rest of the panel.
Hi, it's a pleasure to be with you. My name is John Malcolm. I'm the Vice President of the Institute for Constitutional Government at the Heritage Foundation. I guess I'll begin by saying that I admire your stamina. And the second thing is that I think it's pretty unusual to have the ACLU and the Heritage Foundation testifying on a panel together in support of a piece of legislation. I want to begin though by saying that, look, I recognize that law enforcement officials, and I was a federal prosecutor for 10 years, have a very tough and dangerous job to do, and that they should be very generously funded. So any calls for civil forfeiture reform, at least by my lights, is about rebalancing a skewed and unfair system. It is not about depriving law enforcement authorities of the money that they need or reducing their budget. So let's step back a second. So imagine if you had a judge, and the judge would impose a lot of fines on people who appeared before him using very loose standards to determine how much to impose and when to impose a fine. And then imagine if you discovered that that judge was allowed to keep all the proceeds from those fines to increase his salary or the salary of his staff members, improve the conditions of his courtroom or chambers, or spend the money on lavish trips for training exercises and judicial conferences. And then what if you discovered that the judge really never had to account for how much money he had raised in fines or how he was spending these funds? I think that all of us would howl and protest about that, about this being a very unfair and opaque system, even if in fact a lot of these fines were justified based on the behavior of the people who appeared before them. Well, this is kind of how the forfeiture system works. Law enforcement officers can receive money and property by claiming it was used to commit a crime that represents the proceeds of crime. They can do it without ever charging anybody, much less convicting anyone of a crime that might otherwise justify the forfeiture. And moreover, once the property is forfeited, the law enforcement agency that did the seizure gets to keep all of the property and the proceeds derived from that seizure with very little transparency about how much money they've raised or how it was used. So civil forfeiture, which has an ancient lineage, has very, very noble intentions, and it's designed to deprive bad guys of their ill-gotten gains and the property that they use to commit crimes, and to make it so that it's no longer acceptable as a cost of doing business to just go to jail for a while knowing you're going to have the money available to you when you get out. But despite these noble intentions, the procedures that are currently being used are unfair, and I don't think that law enforcement authorities, however deserving they may be, should be able to write their own checks without going through the legislative appropriation process, using an unfair system with very little oversight. 20 some odd states in the last few years have reformed their forfeiture laws to make them more transparent and fair, most recently Iowa and Arizona, and I would urge you to consider doing the same.
Thank you, sir.
Good afternoon. My name is Robert Everett Johnson. I'm an attorney at the Institute for Justice. The Institute for Justice is a nationwide public interest law firm. We litigate cases against the government. And we've litigated numerous civil forfeiture cases across the country, including representing Russ Caswell here in Massachusetts. You'll hear from Russ in a few minutes, but just very briefly, the law enforcement attempted to forfeit Russ's motel, his family business, not because of anything that he did, but because guests in the motel were allegedly committing crimes in the rooms. And this is civil forfeiture. It allows the law enforcement, police, and prosecutors to take property based only on suspicion of a crime, and then force property owners to prove their own innocence in order to prevent that property from being permanently forfeited to the government. This takes the American presumption of innocent until proven guilty, and it turns it on its head. And worst of all, when police take property using civil forfeiture, they get to keep it. And this creates a perverse incentive that warps law enforcement priorities. At the Institute for Justice, we did a comprehensive study to rate and rank forfeiture laws across the country. And we found that Massachusetts has the weakest protections for property owners of any state in the country. Only one other state is even comparably bad, and that is North Dakota. So that's why Massachusetts earned an F. The only other state to earn an F was North Dakota. In Massachusetts, the standard to forfeit property, all law enforcement has to show is probable cause that a crime occurred. That's the lowest standard known to the law. Then once property has been taken, 100% of the proceeds can go to law enforcement. 100%. We also ranked states based on the transparency of their civil forfeiture laws. And in this area, Massachusetts earned a D, so better than an F, but it's still a failing grade. So Massachusetts can and should do better. Numerous states have reformed their civil forfeiture laws, about 20 as of today. And I hope that Massachusetts will be the next. The proposal that's been put forward is a strong proposal, and it will go a long way towards solving this problem. So I hope that Massachusetts will join the movement of other states that have done this and bring the unconstitutional practice of civil forfeiture to an end.
Hi, I'm Russ Castle. As Rob said, I was a victim of these civil asset forfeiture laws, which, in my opinion, are nothing more than legalized theft. Now, the police would come around to the motel. We always got along fine with them. We never had any problems with them, and they say in their depositions and all that. We help them all we can, completely cooperate with them. Never kept them from doing whatever they wanted to do around here. They take rooms for surveillance now and then if they want to watch somebody else and so on. And they never told me I ought to be doing anything different. I never got a letter from them about anything. And in fact, they're very secret. They won't tell you anything. If I see them in there, go to a room or whatever, I go out and try to find out what went on, or is there somebody we should be putting out or whatever. They give you something like, oh, it's under investigation, or they're vague. They just won't tell you anything. And the same with the town people. They give us a permit to operate every year. Never warned us about anything, or told me we should be doing anything any different. And we were going along just fine. And then one day I get the mail, and there's these 2 forfeiture notices in there. I didn't even know what they were.
May I ask for clarity, what district attorney or entity brought this case against you?
The woman that just retired a short time ago, I forget her name.
This was...
Carmen. Federal forfeiture. Yeah, right. Okay. And anyway, I never got any letters for anything I should be doing different at all. And then I get these forfeiture notices, and they had a bunch of legal jargon in there, but basically they said, we're taking your property. And I was dumbfounded. I asked everybody around there that worked there, they know anything about any of this? Nobody did. So I figured it had to be some sort of mistake, that they either thought I did something, or somebody that worked there did something, or whatever. I was just puzzled by the whole thing. So we deposed, I think at the time it was about 8 of the police in my lawyer's office. This is before the Institute for Justice got involved. And they had nothing to say against us. They say in their depositions, they say I would cooperate with them and help them all we can, and they complete run on the place, whatever they want to do around here. So I felt like getting up there, what the heck are we doing here? But I didn't. And so then we got to this DEA agent, Vincent Kelly. And my lawyer asked him, how do you pick a property to go after over any other property in the area? Because right near us there's a Motel 6 and a Home Depot and a Pancake House and a few other businesses which have more problems than we do. And he says, well, I go through the newspapers and go on the internet looking for some place that may have had some kind of drug activity on it. And then I go to the Registry of Deeds to find out who owns the property and how much equity they have in it. And my lawyer says to him, What's the equity position got to do with anything? Now, the motel is paid for, and I just sold it for a little over $2 million. He says, well, we won't go after a place unless the owner has $50,000 worth of equity. So that tells you right there exactly what this is about. It's not about drug offenses at all. It's about stealing property from people.
So thank you, sir, for your testimony. And clearly that's the egregious case. Any questions from members of the panel? Let me say something, okay? I'm very open to this, speak for myself. I'm very open to this issue, but it would be a lot more compelling if we could come up with some Massachusetts narratives driven under Massachusetts law as opposed to federal forfeiture law. In other words, you give us a grade F, but I'd be much more moved, but that's sort of a theoretical bunch of policy arguments. I'd be much more moved by a bunch of Massachusetts examples of abuses. I mean, I can read those and I've read articles about things happening in other states, but I need the narratives in Massachusetts. Otherwise, it's not going to get to the top of the list. We've got a whole bunch of people telling us personal stories about things that we need to fix in Massachusetts. For right now, I have your issue as a theoretical issue, not as a practical issue. So that's the evidence I need to get interested in, some more focused on. I'm interested in it, I get it. I think that kind of story is horrible. But I need to be Massachusetts abuses before we can go through something like that.
So one thing I just want to say in response to that is the federal and the state law enforcement work very closely, hand in hand on this. And so this was a federal prosecutor, but this was something that was the federal prosecutor working together with the state.
Federal courts, we change our laws, it doesn't fix it.
Well, that's actually not true, because part of what this bill would do is it would prevent state law enforcement from transferring property to the federal government to seize property under federal law. So that in fact is not.
The government can still bring a case against its job.
Well, but they wouldn't be able to bring a case like this where they're cooperating hand in glove with state law enforcement. What this case shows is the way that state law enforcement is being driven to work with federal prosecutors on cases like Russ's by the profit motive that they can get from forfeiting money. When money is seized and forfeited under federal law, there's a kickback of up to 80% that goes back to state law enforcement. And that's part of what this bill would end. It would end that kickback, and it would end the incentive of state police, like the ones who were involved in Russ's case, to cooperate with federal law enforcement on things that should not be any sort of an incentive, or there should be no interest in state police to cooperate with federal prosecutors to take Russ's motel, and that's one of the things that this bill would end.
Just the evaluation of the F is on Massachusetts state laws as well.
Oh, and yeah, I should know, I mean, the evaluation, obviously, you say it's theoretical perhaps, but the evaluation was based on Massachusetts law, not based on federal law. But I think really the important...
We'll look at it somewhere. But as I said, the more Massachusetts specific, sort of straight up state prosecutions you can bring forward, or state forfeitures you can bring forward, that's the more convincing it gets. The more it gets up on the list of things. It's already convincing as an issue, but in terms of spending the political capital, because there's a lot of money. I mean, this is not an easy fight. It's not an easy fight. I've gone through this issue, and the DAs range from 10 to 15% of the budget, 5 to 15%, and it's a significant jump in the DA's budgets. And so taking that money away, no small thing.
And about a third of that money is equitable sharing money that's coming from the federal government in federal prosecutions cases just like Russ's.
So this is a big deal, and to get you got to come up with more Massachusetts entirely driven kind of cases before we get it done. That's what I consider. All right, thank you. Any other questions?
Could I just give a quick statement? Am I done?
Yeah.
Okay. Just think about it a little bit. The drugs come in from Mexico. They come into this country. They come all the way across the country through, I don't know, 7 or 8 states. Nobody catches them. The police, anybody catches them. They get into Massachusetts, nobody catches it. These are the people that are getting paid to keep drugs out of the country. It gets into Massachusetts and into Tewksbury, and nobody catches it. But when it gets onto my property, all of a sudden it's my fault. And they want to reward themselves for failing to keep drugs out of Tewksbury, which makes 0 sense to me.
Yes.
So, if one were to listen to just what was said today, it sounds like you sent a letter and just come and seize the property. Doesn't that ignore the fact that there is a civil court case apart from criminal, and there's also an Eighth Amendment protection if this was so distorted that what the law enforcement took, that there is an appeal beyond that. So I just don't want the impression left that somehow we're just sending a letter to the law enforcement and based on some more probable than not standard that innocent people have the property taken. Is that fair to say?
Well, I want to be clear. The standard you're right, there is a civil case that is filed, a civil forfeiture action, and the standard in that case is probable cause. So all that the government has to show to prevail in a civil forfeiture case is probable cause that a crime occurred, which ordinarily is the standard to seize property temporarily, not the standard to keep it forever. And that's precisely why Massachusetts got such a low grade, because that is just an incredibly low standard.
I just didn't want to leave the false impression, though, that somehow people are saying that because a criminal act may not have been adjudicated. It is, and this is very well settled. This is two separate tracks. It's a civil forfeiture. It may arise from a criminal allegation, and there is what I would consider to be a pretty robust Eighth Amendment protection as well.
Well, the Eighth Amendment comes into play only at the end of the case. So in Russ's case, for instance, we litigated for 3 years before we got to the end of that case, and at that point we won. But there's no point that you can raise the Eighth Amendment as a defense until you've lost, which is going to be years down the line. So as a protection, that's not a protection. What you need is to have something at the front end to protect people at the front end. And again, making it probable cause as the standard in a civil forfeiture case is the lowest standard known to the law. It's practically not a standard at all. And it's no protection for property owners.
I appreciate that. I don't mean to be rude, but I think Chairman Brownsburg raised the point that the case that you brought to the egregious as it sounds is a federal case. And I'm interested in hearing some of those Massachusetts cases if they are in fact existing as well.
Well, there are absolutely Massachusetts cases out there, and I hope that one will be brought before you. Again, though, I would emphasize that this is a case that involves state and federal prosecutors or personnel working together, and it is exactly the kind of case that is addressed by this law with its limitations on equitable sharing, or this bill. So I appreciate that there could be other examples that are even more compelling, but this is absolutely something that would be addressed by this bill and would be prevented by this bill. Thank you.
Okay, thank you for that clarification. Thank you very much for your testimony.
Could I just say one thing? The judge wrote a 60-page decision on this case, and it was totally in our favor. She accused the prosecutors and police of just gross exaggeration of the facts and everything else. There was nothing in there against us. It was all about them using their authority to just bowl over people like me.
I had a terrible example of the question. Brian, thank you. Let's see, did I tell you, were you expecting me next? Sorry.
Yes, we had a bus that was leaving at 5. We know we were close on the list. We don't know.
Okay, all right. What do we got here? Come on up.
Okay, thank you. Thank you to whoever was
We're trying to follow.
Thank you.
I just want to say to everybody here, we're trying to follow the line here. We're working with a lot of people here.
Thank you very much to those that we came in front of. I want to thank you to the Joint Judiciary Committee for hosting this hearing. Our group is representing EPICA and Jobs Not Jails. We are here today in support of bill numbers HB 2308, the Justice Reinvestment Act. Also HB 3084, an act promoting community prosperity by further reforming quarry. And SB 777, an act to reduce criminalization of poverty. I want to just state first that passage of these bills is very important to our members in our community, as we feel that these bills will replace despair and despondency with hope and opportunity. Despair and despondency, our EPICA members see first thing in the morning at 8 o'clock in the morning when we arrive on King Street in Worcester, Mass. There is a homeless person sleeping on the front lawn. And then we see when we leave at 8:30 p.m. at night, there is a couple that leaves their blanket on the fence that roll up together and sleep onto the sidewalk across the street. A lot of Worcester's homeless are also formerly incarcerated folks with CORI records that prevent them from entering housing and employment opportunities. So these bills, the passage of these bills are very important to our community. I was hoping that the district attorneys had stuck through and listened to the rest of the community instead of just speaking and leaving, because it's just very important that they hear this side, and unfortunately we feel that sometimes that they don't.
D.A. Ryan is still.
Oh, okay, D.A. Ryan.
Who is the president of the district attorney's?
We would.
You have good eyes.
Yes, we would love to, invite the district attorneys to King Street and to see what we see. Like I said, the despair and despondency of this population and the need for change in these bills, because it affects a lot of people that are in poverty. And the bills address these things: reduce criminalization of poverty, promoting community prosperity by further reforming CORI. And I would just like to add that I am here personally. There was supposed to be another member speaking today. Her name is Y. She's a Cherokee Indian member. Her actual name is Wahaya. I don't want to, so she always says, call us Y, so I don't want to destroy her name going forward. So she was here, she was scheduled to testify today. Y has a story where her daughter is dealing with in the grips of addiction, and she's very worried about, the safety of her daughter. And Y herself was homeless when she came to Epica, and she was formerly incarcerated, and, for resisting arrest. And so there are CORI issues that she would like to, to address. And so what happened is she received a call while we were sitting down talking that her daughter was being arrested on King Street. She ran up and the daughter says, oh, Mom. And the officer says, oh, could I see your ID as well? So Y had a warrant that she was just telling me about for unpaid fines for probation. So, Y was arrested and, wasn't able to speak today. But I just wanted to mention in ending also that, we need to start worrying about, the opiate problem. We use 95% of the world's opiates, and we're only 5% of the world's population. And, a lot of these are not street, dealers. These are pharmaceuticals that, need to be held accountable, because a lot of people that use opiates further use heroin because heroin is cheaper, when their addiction gets really a strong grip on them. And, it's just intertwined with homelessness and, joblessness, and we need to remove these obstacles, and we really like to have your support in passing of these bills. Would be great. Not passing on, sorry.
My name is Lindsay, and I'm a person in recovery. I've done a great deal of work on changing not just the not using of drugs, but also my behaviors that led me down the wrong way. I've worked very hard to change the person I am today. I understand I had to pay for my mistakes, but not for the rest of my life. Being constantly reminded of the wrongs in my life takes away from the good and hard work I have put in to not just my recovery, but my everyday life. Not having the opportunities to find suitable work because of my past mistakes keeps me at a standstill for not being able to better my overall quality of life, not being able to get the certifications I need for better jobs and for a career that I'm passionate about. It's like punishing me again and again for my past. I ask that you take strong consideration in changing these laws so people like myself that have found a new way of life and have bettered their days are able to prosper to their full potential. Thank you.
Hello everyone, my name is Ray Rivera, and I am in support of Senate Bill 755 and House Bill 3077. I came with EPOCA today on the ENCODE GPS bracelet from State Parole, and I was told that if I don't have the $80 in 26 days that I have to pay monthly, I will violate the parole, not because I broke the law, but because I don't have a job, I'm homeless and I'm poor. I've been out 7 months, and I've been looking for a job, and nobody want to hire a guy with a bracelet and the ankle, because people think like I'm a bad criminal. And I changed a lot. I spent 2 years in jail. I still got 2 years to go on parole, and definitely it's hard for me to find a job. I've been looking, and I just want to ask that you said get rid of the probation and parole fees. That's why. That's it. Thank you.
Thank you guys for having us. Well, you guys stole my line. I'm gonna say you guys are really good. Be sitting here all this time and have to go to the bathroom. I say you guys had it all this time and had to go to the bathroom. You guys are really good. You're glad I'm strong. Okay. But anyway, I'm here with Steve with Epica and Jobs Not Jails. I do the Corey workshop all over the state. I go where people ask who need help sealing their records. Also, I find a lot that people who have dismissals, quaffs, and they have to go to every state, every court that they have cases in. And it's a burden on a lot of people to get to all those places. Even though cases are dismissed, I believe they should automatically come off their people's records. Also want to speak on mandatory minimums. The DAs, what the DAs didn't tell you is that a lot of times when they have people cop out, they get the mandatory minimum sentence anyway. And those people are not allowed to go to pre-release or work release or, to get lower levels of imprisonment. But also I'm going to speak on larceny over 250. I know when people go in the stores, they don't go in there with a calculator. I'm up to even larceny is $250 or $1,500. I'm not going to the store and I got $249, I got $14.99, I have a misdemeanor. I'm not going in there, they're not going in there to count what they take. We're here to help the people who are trying to change their lives, not people who are trying to help criminals, so we want to get that clear. We want the people who are trying to become productive members of society again. That's why we're here to fight all these laws, these changes, and try to make changes in law for people who are trying to do the right thing today. Thank you guys for having us.
Thank you so very much for this one. I want to go back to the gentleman before. You were on parole.
Yeah.
And you were told that if you did not pay your parole fee, you would be incarcerated?
Yes, it's correct.
That was said to you.
Yeah.
Anybody else have that experience of on parole being told they did not pay, they would be incarcerated?
Our clients, yeah.
Okay. All right.
It happens all the time.
I just wanted to verify that, because that's some of the things we're concerned about. So you know, in the Senate budget, we actually didn't repeal parole fees, but that's still subject to negotiation with the other branches, so we're making that statement. Not sure we'll be successful given the way the state's losing money right now. That's one of the worst things, so we appreciate your testimony.
Okay, thank you.
Thank you, sir. What's going on over here?